Bye.
My ladies, I call the matter of Thales, South Africa, PT1 Limited, J.G. Zuma versus the Director of the Prosecution's case again and others.
Thank you. Can we just interpose Mr. Masugo for a minute? Yes. Yes. Yes.
Okay,
Yes.
people will switch off their cell phones.
Yesterday, my learned leader had indicated that we were not going to make reference to Mr. Trencroft. In my address, I did. I hope the context was understood. It was not on his conduct.
Yes.
And so no reference should be made to the conduct that we undertook to not to mention. So to the extent that my reference to his lecture was misunderstood, I apologize.
Are you happy with that? Yes, certainly. Thank you. Thank you, Mr. President.
Thank you, my lords. My lady, yesterday, before we I gave that Thales has approached the court about. And I explained that there are two baskets of relief. The one relief relates to what we emphasize is the conduct of NDPP Abrams, and that is a constitutional matter within this court's power, and the court will analyze and interrogate what Mr. Abrams did and didn't do, and we submit that what he did in deciding to reinstitute against our client doesn't pass constitutional muster, and this court is then obliged to come to our client's assistance and make a declaratory order to that effect. A second basket, a separate self-standing basket, not dependent upon Mr. Abrams' conduct in any way at all, is that just like Mr. Zuma, we argue, perhaps on different facts, that our client is entitled to a permanent stay under section 172(1)(b) of the Constitution, and our submission is that would be the just and equitable relief on the basis of what we would call the facts and circumstances that this court is bound to accept. In preparing our oral argument, we prepared a note on oral argument in respect of the first basket, that's the Abrams conduct point. But in the note, we set out a whole series of what we would call legal propositions which affect both the Abrams basket and the permanent stay basket. But before I get to the note, which we will hand up in 1 second, I do want to emphasize the following. In the replying affidavit, at page 730, our client makes the following statement at paragraph 160, and we would ask that the court have regard to what our client says throughout my address on the Abrams basket. And what the deponent says at paragraph 160 is this: indeed, Abrams was hell-bent on prosecuting Thales, and whatever representations were made would have made no difference to him. This is one reason he did not give Thales a hearing before making his reinstitution decision. Now, if that's accepted by the court, then it's clear, just on this basis, leave aside all the other bases that we bring to this court, the Abrams decision must fall and be entitled to Pres 1 and 2. Because we know, as a matter of general law, that where a decision maker, the repository of power, has the discretion to make a decision and he closes his mind to the exercise, he fetters his own discretion, and that's unlawful, and I'll give you the cases as I develop my argument. Hell-bent representations would have made no difference is clearly, if the court accepts the submission or the averment, clearly a fettering of his own discretion, his prosecutorial discretion, and the exercise of his prosecutorial power, and his decision must fall. Now, in order to demonstrate how it is that our client came to that conclusion, it is perhaps worth going back to how it came about that Mr. Abrams made his decision. And for that purpose, I do wish to just touch upon certain of the letters that he himself wrote. Now, when we look at his letters, and I ask the court to take this submission into account, when the court considers what he wrote, the court will know that in the Zuma DA case, the NAFSA DP judgment, there is and I'll come to it in my trite propositions of law, a statement to the effect that when a court looks at the reasons given by a decision maker, they may only look at the reasons that he gives in letters and not expanded ex post facto lawyers' letters, lawyers' reasons. I'll come to that. Perhaps I should do it right now. It is in volume 1 of a bundle of authorities. It's the Zuma versus DA case on page 33, paragraph 24. Perhaps I should take the court to it right now. Because in analysing what Abrams did or didn't do, page 33 of the bundle of authorities, and it's paragraph 24 of NAFSA ADP's decision.
Paragraph 24.
24 on the left-hand side of the page, on page 33 of the bundle. Of the NAFSA decision. What NAFSA ADP says is this. On 6 April 2009, Mr. Mshe announced publicly that he made the decision to discontinue the prosecution of Mr. Zuma and issued a detailed media statement providing the reasons. Now, in our case, there is a media statement, but we'll talk about that as time goes by. But what is important for now is the letters. The next sentence is crucial. It is against those reasons and those reasons alone that the legality of Mshe's decision to terminate is to be determined. So when Mr. Abrams gives a reason in a letter for anything that he does, it is those reasons and those reasons alone that this court will determine the legality of what Mr. Abrams did. And it doesn't matter what he says in an affidavit thereafter.
Why does it not matter, Mr. Katz? I thought if we are dealing here with a matter, an opposed matter, then most certainly it means that those affidavits will have to be considered in dealing with the reasons. One can't say only correspondence will constitute reasons.
With respect, if you look at footnote 11, National Lotteries Board, in that judgment, what happened there was that the National Lotteries Board gave reasons in correspondence as to why they rejected a particular application for funding. They were challenged, went to court, and they made an affidavit. And the affidavit provided different and expanded reasons to that in the correspondence. And the SCA said that when it determines the legality of what the National Lotteries Board did, it can only look at that which is in the letter. What is expanded upon in the affidavits is not relevant.
But you've got to understand that that decision, the unlawfulness of Mshe's decision, it was intertwined with Thales' withdrawal of the charges.
Excuse me. Sorry.
You've got to understand that the unlawful decision of Mshe was intertwined with the withdrawal of the charges against Thales.
Yes.
Yes, you've got to understand that.
No, but what happened was this.
It is in that context that you've got to...
Sorry. I'm talking as a general proposition now. That
But
when...
Sorry, Mr. Katz, I'm not with you. You're saying that the reasons in this paragraph 24, we must read it to mean that the reasons that are considered are only the reasons in the correspondence and not the reasons provided in the media statements.
Not reasons provided ex post facto in the affidavits. You can't say, Abrams, decided on reason X in a letter to Mr. Dryman. Then he gets challenged, and he says in affidavit, I relied on reasons Y and Z. That's not permissible.
But
and
the
court will...
It's on that basis that I'm asking you, is that decision not intertwined with the withdrawal of the charge against Thales? Because that's a key thing here. The Mshe unlawful decision of Mshe is intertwined with the withdrawal of the charge.
It may or may not be. Justice Mguni...
Does it matter? If once I make a declaration that is unlawful, does it really matter that I come up with it? If it is intertwined with that decision?
No, I understand.
Yes.
I understand. My Lord, I'm going to be like a stuck record on this point.
Yes, but
Abrams could have had 10 good reasons intertwined with the unlawful and shared
did he
decision,
have to
etc.
give any reason, for
Sorry?
instance? Did he have to give any reason?
We'll come to that. But when he exercises a power, which he does, and I'll come to all this, he must, one, have the power, and he must know what power he's exercising. If he doesn't know what power he's exercising, it's an unlawful exercise of power. It's the same point. And in paragraph 7, he writes to Mr. Drama, as you are aware, I am presently considering the matter in terms of the provisions of section 179, sub 2 of the Constitution, and not in terms of some other sections.
Where are you reading from?
From paragraph 7 on, paragraph 7 on page 75 of Abrams' letter of 14 February 2018.
So what is the page?
Page 75 of the pleadings record.
75.
The argument that I'm now making will track right through all the legal propositions that I'm going to advance, together with a whole range of other factual issues which we submit demands that Abrams' decision be set aside. In paragraph 7, are you with me, my lord and my ladies? As you are aware, I'm presently considering the matter in terms of the provision of section 179(2) of the Constitution and not, and then there's some other sections. For purposes of today's debate, that's what your ladyships and my lordship will determine. Our learned friends come up with an argument that is not in the correspondence, nor is it in Mr. Abrams' affidavit, that he was empowered under section 22(1) of the NPA Act to make the decision. We submit that's wrong as a matter of law, but before you get to whether it's wrong or right, they're not entitled to rely on the section, because they are bound by the 179(2) reliance by Advocate Abrams for his decision-making power. That's what he says he made the decision on the basis of, and that's what he is bound, and the respondents are bound by. They may not say, well, he had the power, but he didn't know that he had that particular power under 22(1). That is not permissible under the case called Minister of Education versus Harris, referred to in that judgment of NAFSA ADP. I will come to that. But your lordship and your ladyships know that our learned friends say in paragraph 556 of their heads, this is what they say: Mr. Abrams thus had the power in terms of 179(2) of the Constitution and section 22(1) of the NPA Act to decide on behalf of the NPA to prosecute Thales. They may not do that under the Minister of Education Harris line upheld in Zuma versus DA. Section 22(1) is not before the court as a source of Mr. Abrams' power.
But what is the purpose of legal argument?
Yes.
If you cannot refer to the correct provisions in the Constitution, why must we have a legal argument?
In the Zuma versus DA, the example is this. Under the old common law Latif line of cases, what happens is this. You will see Latif referred to in paragraph 55 on page 39 of the Zuma case. What Latif says is this: the administrator decides to declare a provincial road a public road. And he says, I hereby declare that road X is a provincial road under section 8 of the ordinance. It turns out that he had the power to declare the road a provincial road, but he only could do it in terms of section 4, not section 8. Under the common law, not a problem. And if there's a challenge to his decision because he relied on the wrong section, it wasn't a problem. Under the Constitution, which we are now under, it is a problem. Abrams must know the section that he's relying on when he makes his decision, otherwise it must go down. And that is set out in the next paragraph 56. In its additional heads, counsel on behalf of the NPA sought to distinguish the decision of the Constitutional Court in Harris. In that case, the minister invoked, etc., a section of the National Education Policy to determine age. It was a power he did not have, and the court held that to be so. That's the point. It's not good enough, Justice Poyodlawati, for what you suggest is legal argument to save Mr. Abrams because he didn't know what section he had to rely on. Not good enough. That's what Minister of Education versus Harris says. When a decision maker, like the minister in that case, took a decision, and I'll read the words here, invoked Section 3, sub 4, little I of the National Education Policy Act to determine the age requirements for school. It was a power he did not have, and the court held that to be so. Not good enough. And your court is bound, I say, and the respondents are bound to accept that Mr. Abrams' decision could be saved only by Section 179.2 and nothing else. And our learned friend's invocation of Section 22.1 of the NPA Act doesn't assist Mr. Abrams at all. That's the common law proposition, not under the Constitution. So by way of introduction, I have explained those aspects. I also wish to turn to other difficulties that Mr. Abrams, as correspondence, provides. And that one sees, for example, where he rejects Thales. Sorry,
You were going to give us a
You
note.
said you're going to give us
no, yes, I just wanted, this is the introduction. Which I'll come
to your oral
yes,
argument.
your oral
Okay.
argument, this is, I'll come to it.
No,
I'll
no,
come-
we just wanted to make sure.
I'll give it
that-
right now, my lady. I'll give it right now. It's coming. But I wanted to explain these aspects. What I don't want the court to do is to delve into the note without understanding how it is that we come to the conclusion. Before your ladyships and your lordship read the note, I want to make one other point. And it's key to our Pres 1 and 2. This is a note on oral argument. It's got trite propositions of law which apply to both the permanent stay and the unlawfulness of Mr. Abrams' decision. The other point that I wish to make up front. Yesterday, we heard long argument about violation of rights in the context of a permanent stay application. We will make that same argument of violation of rights when we argue Pres 3, the permanent stay in our case. However, the legality challenge does not require, and we want to emphasize, does not require a violation of rights. Mr. Abrams' decision will be judged in terms of the objective legality, the arbitrariness, the rationality, etc. Did he have the power? And if he did have the power, did he exercise it properly under the Constitution? How it affected Thales is a different debate. It's not something that will go into the court's decision-making. It's an objective test, perhaps like an objective test when it comes to a pudger, but this is a legality challenge. And legality, like ex parte pharmaceuticals, there was no respondent. President Mandela had made a mistake on his version, so President Mandela went to court and he said, please help me, I've made a mistake. I've acted irrationally, set aside my decision to bring into operation the pharmaceutical regulations. No violation of rights. Abrams' decision stands or falls on its objective rationality, legality. Did he have the power and did he exercise it properly? And we emphasize that, which is going to be a dominant theme of how it is that we present our case on the Abrams Pres 1 and 2. It's very different to the discretion that this court has when it comes to permanent stays, violation of rights. By the way, my lord, I was told by one of my juniors, or my junior, that your lordship mentioned Section 36 and the balancing limitation of rights when it came to violations. In our, I don't know if Section 36 has no role to play, this limitation of rights debate has no role to play. If there is a violation of rights by conduct, then it cannot be saved by a Section 36.
Are you referring yesterday to when my brother dealt with the balancing of rights, which is different?
No, I accept that.
Not the
I accept
limitation clause.
No, I accept that. I agree.
It was the balancing of rights, which is a very important
then I was
exercise in the
informed
stay application in light of the Sanderson decision and
Just the
those
same,
comments.
if that's, I accept that unconditionally.
Yeah.
I was told, and I was told wrongly.
Yes. Wrong information.
And I apologize. But I also didn't hear Section 36 being mentioned, but yes, it was. I think it was, anyway. So we start in, I'll turn to the note. This application concerns the reinstitution of proceedings against Thales. Thales challenges Abrams' decision against it on 3 separate but interrelated grounds, etc. First, this is paragraph 3, was unlawful, and your lordship and your ladyships know I made this point yesterday, paragraphs 3 and 4. Just for the sake of completeness, in paragraph 5, I made the point yesterday that a permanent stay under 172.1b, even the absence of making a 172.1a declarator, is available. On the next page,
Sorry, Mr. Katz, just for, so that I understand. So you'll be reading from the note and also your heads. How are we going to?
Yeah.
I'm not. I don't know.
I'll read from the note.
See, I think let's go back to the drawing board. I think it's important for you to look at your heads, because in your heads of argument, you make a meal of section 22, subsection 9,
Yeah.
which is very important. We want you to address us on that. Let's go back to our heads and stick to our
Just a
to the
minute.
heads.
I was expecting that question
Yes.
because of the debate that we had yesterday.
I see here you're trying to avoid it. I think you have to face it now.
Because we haven't read this.
Justice
Go
Nguni
through it. It doesn't appear there.
and my ladies, I will never avoid that.
Let's
It's
deal with
in
it.
my DNA to argue it, but
Yes.
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 I want
let's-
to make a big but,
yes.
and I ask the court's indulgence. In order to argue it properly and to provide the court with a proper argument on 22.9 and the interpretation of 22 as a whole, and the interplay between 20 or the NPA Act and and Section 179, I ask the court to indulge me, even if it's for half an hour, to build up to it, to set up the various parameters in respect of which we submit the court has to deal with that particular argument. The court will see in this note we have gone chapter and verse into 22.9, and it starts. Let me just explain where it starts. It starts on page 17, paragraph 18.
Mr. Katz, this note, I have a problem with this note, because when I prepared, the reason why we have heads is for us to prepare and read the papers together with the heads. Now, if you're going to refer me to this note, which I haven't read, how am I supposed to follow? The purpose of the heads of argument is for us to follow your argument and engage meaningfully with you.
I accept it unconditionally.
So if you want to persist with this note, then I think we should have time to read it.
Well, no,
I think-
let me can I make a
Let's
suggestion?
just start where we're supposed to start. Let's stick to your heads, and so
Well-
that we can follow the argument.
Well,
Because
Justice
that's where we're
Poyet-Lawati,
supposed to
two
start,
things,
yeah.
if I may.
Please.
You're very welcome to hand me the note back, and I'll orally argue. You don't need the note. This is just to make it easier for you that what you would be writing down about what I say is in written form.
No, we
So-
understand that, but can you follow your head so that we can also follow you?
Well,
Please.
Sorry, I can argue either way. I'll argue the section 20, and let me say, Justice Poyet-Lawati as well, the reason for this note is to assist the court. You can give it back to me, I'll take it back. The reason that we've done it is to assist the court, and where we reference, for example, our main heads of argument, the record, and importantly, which you haven't had an opportunity to deal with, our arguments vis-a-vis the state's heads, which we only received last Friday. And those heads are 263 pages, and they include the argument against Mr. Zuma. And we think it's not fair to the court that the court has been put in that position, that 5 days before a hearing, or 7 days before a hearing,
We haven't complained about papers. That is not something.
but our argument,
Sorry, Mr. Head, can you just leave that to us? It's for us to decide. Can you please stick to your heads? We'll try and follow your heads, and so
you
that
don't
we
want me
can
to
be
refer
able
to
to follow your argument. We appreciate your notes, but can we follow the heads of argument?
the
Because
lawfulness of the
that's-
decision
that's-
starts on
that's-
page 21 of our heads.
Yes, I think let's follow that.
The
Because
lawfulness starts on page 20.
I hope it will take us somewhere, but let's just stick to that. Yeah, please.
78. Paragraph 78, the Constitution enumerates the powers, functions of the NDPP and recognizes that DPPs are primarily responsible for prosecutions in specific jurisdictions. To this end, Section 179(3)(b) states national legislation must ensure DPPs. What will be helpful in following my argument is in our Bundle of Authorities, Volume 1. At the introduction part, we have extracts from the Constitution, and in particular on page 3, we have the whole of 179, and on the next page, we have the whole of the NPA Act. And I'm going to turn to those documents in developing the argument as to 22.9. So in 79 of our heads, we say 179(3)(b) talks to who, and we emphasize who is responsible for prosecution in specific jurisdictions. 80, the powers of the NDPP are enumerated in 179.5. And if one has regard to those provisions, it's on page 3 of our bundle, one sees that in paragraph or sub 5, the enumerated powers are listed.
Yes.
It says that NDPP A must, B must, C may, and D may. And we say in paragraph 80, those are the powers the NDPP has. And we say in paragraph 81 that although the Constitution does not recognize an independent right of the National Director to institute and conduct, it does allow the NDPP to intervene in prosecutorial decisions, and we give this section. It does this in important ways, but before I get that, and I'm going to jump ahead and reflect back, it's in our heads, and it's in our replying affidavit in some detail, with reference to an article written by Professor Van Zyl-Smit and her ladyship. That before, in 1992, leading up to 94, there were various attorneys general throughout the country.
I'm glad you're getting to that point, Mr. Katz. Let's look at that, because one has to finally remember, as we referred to in an earlier article in a previous life, the 1992 Attorneys General Act. There was an Attorney General for each of the provinces. In those days, it was pre-1994, there were only 4 provinces. And if one considers the powers and the duties of the Attorney General in each of the provinces, and bear in mind, if we look at section 179 as to how the prosecuting authority in the Constitution would operate, and we compare as to the 1998 Act, then the National Director of Public Prosecutions is in the same position that the Attorneys General was in the 1992 Act. So, in the delegations, then to each of the prosecutors flowed from the Attorneys General. Now that delegation flows from the National Director of Public Prosecution, which has in each province now, as we have changed, a Director of Public Prosecution. But it did not mean that each Attorney General had to prosecute in every matter him or herself. In fact, it was mainly himself in those days. So when I follow your argument regarding Mr. Abrams, that ought to have personally dealt with the matter, I really have a problem in understanding it in terms of section 22, coupled and also juxtaposed with the old 1992 Act.
See, just to add on that, my major problem with your argument on section 22.9 is this: have we reached that stage that you can raise this issue as an issue before us?
All that has happened is,
Yes.
is the preliminary proceedings into the prosecution.
Have we reached that stage?
There has not been a
Assuming
plea.
that you're correct in your argument.
Okay, I need to answer 2 questions
Yes.
if I
Yes.
package it. The second
Sorry, we're
question is
bombarding you.
from Justice Mguni and Justice Poyer-Lawati.
Yes.
I'll answer that first, which is, have we reached the stage? And the second question, which is from Justice Steyn, is the
Let me
question...
just expand on it and make an example.
Yes.
For instance, if the national director comes, if the matter is set down for trial, and the national director comes to court and says and appears on behalf of the state and says to the presiding judge, I act on behalf of the state. I would request Mr. Downer to lead the first witness in this matter. It's a simple example. Will it make any difference?
No. Sorry, I have to answer it in the most comprehensive way possible. The respondents accept my characterization of Abrams' decision in paragraph 548 of their heads. They accept it. I'm only answering the Justice Mguni, Justice Poyer-Lawati question now. And what they say is this: Thales is undoubtedly correct in its characterization of Mr. Abrams' decision. He did not decide to institute and conduct the prosecution in person. End of the matter as far as your lordship and your ladyship's
But
question.
we as the court, have we reached that stage that you can raise this as an issue?
Yes, he says so in his affidavit.
No, forget about the affidavit. We're dealing with the civil proceedings here. Have we reached that stage where you can say I'm not saying I must be upfront with you. It's not a sensible, practical interpretation to seek to attach on the section, but that is beside the point. The point is, have we actually reached that stage that you can raise this?
Yes, Mr. Dana appeared in court on the first occasion. He's the one. Advocate Noko, no, sorry, with respect, Advocate Noko is conducting this prosecution. I know she's been moved in the last couple of days to the northwest, but she is the person conducting this prosecution, and she's delegated down to Mr. Dana and the others.
Where is that on the papers?
Mr. Abrams and Mr. Dana say so, all over the case. That's the case.
Where?
Ms. Adhikari will give it to me, but it's all over. That's what Mr. Abrams says. He says, I'm not conducting in person.
No, as I read all these papers, and you can excuse me if I'm making a mistake because they're quite a lot. All I saw is that Mr. Abrams says, then I made the arrangement with Advocate Noko to make the necessary arrangements for the people to appear in court for the first appearance. Yes. That's what I read.
That's what he said.
So I'm not sure if there is more to that.
The NDPP, with respect, and I'll make the submission once, and that's the end of it, did not rely on Section 22.9 to make his institution decision. If the court comes to the conclusion, which we submitted cannot come to, that he was entitled to rely on 22.9, number one.
Yeah. I made an example earlier on. Is that not?
So the example
if the national, he comes to court and says, I'm here on behalf of the state, but my first witness, I call my first witness, but the person who's going to lead the first witness is Mr. Downer. Where does it take you to?
Two places. One, he hasn't done that as a fact.
No, we haven't started the trial.
No.
This is a prosecution. That's why you have a problem. We haven't started the trial. We're still dealing with the civil proceedings.
But in answering affidavit, Mr. A. Sorry, well, let me come back to it. I'll come back to your Justice Mnguni's point. But we submit that the evidence is clear that Abrams, one, did not act in terms of 22.9. He doesn't say so. In fact, our learned friends accept that he didn't do it. They say he did it in terms of 22.1. But let me come back. So to my mind, with respect, that's our submission. He did not rely on 22.9. The respondents' counsel do not say that he relied on 22.9. They accept that he didn't. And their argument is, quite simply, that he had the power. They say, in conclusion, in 556, he had the power in terms of 22.1. That's what they say.
I'm going to get back to, and unfortunately we're going to harper on this issue because it's an interpretation of a particular provision. I understood the arguments of the prosecuting authority to be that the flaw in the attack of Thales is that they think that the National Director of Public Prosecution's only power to prosecute is derived from 22 sub 9.
That is the argument.
Yes, but that's not the only power, and that's why I at the onset said that one has to understand how the National Director of Public Prosecution derives its powers.
I accept that.
And that it is not only limited.
No, I accept that. Yeah. Perhaps Justice Mnguni, Justice Poyodolwati, I'm dealing with two different aspects of this point, but in different ways. And I just want to...
We're trying to understand your
No, I understand, but the two questions that have been posed to me. The one is by Justice Steyn on the interpretation section. The other is on the question of the factual scenario as to whether or not we have reached the interpretation section yet. And those are different aspects. And I do need to emphasize that as far as the questions from my right, Justice Mnguni and Justice Poyodolwati, we say the evidence is clear, the respondents accept. We are at the stage of determining what Justice Steyn correctly in our submission calls the interpretation argument. Abrams is not conducting this in person. No, he says he has other powers. And they say he had the power in terms of 22.1 to do it, and that's what Justice Steyn is pushing me on, and I'll deal with that separately. Sorry, Justice Mnguni.
Can I ask you, you said the evidence points us there. Can you point me there,
I
will.
I
Yes.
will. But if I may just... I know Justice Steyn asked me first, but so...
You can deal with the question, please.
Justice Steyn, in developing the question to me, you went back to the Attorneys General Act and you made the point that the Attorney General had the power to delegate under the Attorney General Act of 1992. Yes. And then you jumped and said, if I may, with respect, summarize as I understood your argument, you said to me, well, when the National Director became a National Director, there was an animal called a National Director, like the Attorney General power to delegate, so he had the power to delegate. No, that's the point. No. And that was what the ANC wanted. And the National Party, and the IFP and the others say that there should be no National Director because the National Director would be a political appointment. So there was a compromise.
But there is a National Director. You see, I'm with you with the compromise, and as you're fully aware, I see you made reference to that old article. It's dealt with the whole development of the issues, how the Minister of Justice should be the one that is finally...
And not a cabinet, all those
yes,
things.
Yes, yes. But what I'm trying to understand, Mr. Katz, is why you say no. So because that is what I understood from the heads filed by the National Prosecutor to say that the argument is flawed. So just explain to me how you disagree with them that your argument is flawed.
I'm coming there, but in dealing with it, I have to analyse your question to me, which was that the Attorneys General had the power to delegate. There was a National Director who similarly had the powers to delegate. I say no, and I'll develop why no. Yes. Because the compromise was, one, there would be a National Director. Because the DA or the DP, as it then was, the National Party, said, I think Tony Leon or whoever it was, said, there should be no national prosecuting person. ANC, Dola Oma said there must be. That was the debate. And the compromise was that there would be a National Director, but his powers, or her powers, would not be the same as your ladyship put to me, like the old Attorney Generals. That was the compromise. And that's what the compromise that we live with today. And the National Director's powers are enumerated in 179.5. That is the compromise. So it's not a compromise that, oh, well, the ANC get their way. No, the ANC got their way that there would be this head of this national authority, but his powers wouldn't be what the ANC wanted them to be. They would be different to that which your ladyship puts to me as like the old Attorneys General. And if you ignore the compromise in our submission, you ignore not only the wording of the Constitution, the wording of the NPA Act, every canon of construction that we've put before the court, such as the nugatory aspects of 22.9, all the types of generalis specialis, and the history and purpose of 179.
But how do you then ultimately deal with your argument in light of Section 22 sub 1 of the National Prosecuting Authority Act?
I will come to that. Sorry,
no, but if you say no, it does not have that, let's just pause and see what the 22.1 says.
Absolutely.
It says the National Director, as the head of the prosecutor, shall have authority over the exercising of all the powers and the performance of all the duties and functions conferred or imposed or assigned to any member of the prosecuting authority by the Constitution, this Act, or any other law. And we know, as for the Constitution, it must be Section 179.
Now, after the court turned to 179.6.
Yes.
To juxtapose what your ladyship has just put to you. 179.6 says the cabinet member responsible for the administration must exercise final, and I want to emphasize responsibility over. And I want to emphasize the difference between the word over and the word to. Your ladyship read to me 22.1. Perhaps I should just read it again. 22.1 says the National Director shall have what? Authority over. Authority over is never a power to. And that's 179.6. The cabinet member in 179.6 responsible for must exercise final responsibility over. It's an oversight power. Your ladyship, I want to emphasize this. Your ladyship put it to me that 22.1 gives the National Director the power to institute. That's your ladyship's proposition to me.
We're dealing with the duties. So if we have, and you say that it does not have the same duties as the old Attorney General, and that's why we have to get back to the powers and duties which is constituted in terms of, and you say there's no delegation.
No, hold on. It's not a question of delegation.
You say it's not the same, it has been a compromise, and we were speaking about the delegation that has been given to each of those under the National Director of Public Prosecution.
Sorry, so we're talking prosecutorial.
22.1.
Yes.
Just
Yes,
do you have 22.1 up
22.1
there?
is crucial to this debate.
Absolutely,
It's
Mr.
the
Katz.
debate. And our submission is 22.1 for the range of reasons that are in my note. Let me say this. Sorry, Justice Poyo-Drawati. You asked me a very good question. Why have I come with this note today? For the first time in the history of this case, were we informed of the notion that Abrams had a 22.1 power last week. Until last week, 22.1 was not mentioned at all. It's not in Abrams' affidavit, it's not in Downer's affidavit, it appears nowhere. It's not in the correspondence. The first time was when I read 556 of our learned friends' heads of argument. That's why we've come late. It's not our fault. We invited them in our replying affidavit, which was...
But were you not interested in the duties and functions of the National Director and how he exercised it in determining the rationality? One has to concern yourself with what are the powers and duties of a National Director of Public Prosecutions.
No.
So this is legislation. And as lawyers, we all consider the legislation applicable to our cases.
Absolutely. And we looked at it very carefully, and we concluded in our heads of argument, in our replying affidavit, that the only power that Abrams had was a 22.9 power. That's our submission, and we stand by that submission. For the first time last week, we heard of this 22.1 power that popped up. Never in Abrams' correspondence, not in Abrams' affidavit, not in Downer's affidavit, heads of argument last week. And I say...
Can we just clear this thing about the heads and last week? The heads are stamped the 10th of May.
That's Friday a week ago.
Yes. So they were received on the 10th of May because I have proof of service on all the lawyers.
No, I accept that.
Yes. Now, if you felt that you had something to supplement your heads, then surely that ought to have happened by last week Friday or yesterday for that matter. All I want to say is, and it looks like I was right, I don't want this note
I'll
to
take
supplement your heads without our knowledge. So at the very least, we ought to have been told that it's a supplementary to your heads.
No, it's not a supplementary note. Sorry, with respect, it's not a supplementary note.
But it's your supplementary note because you're addressing 22.1, which was never addressed by the NPA before. That is what you are saying.
No. When we... I'm not going to apologize because I don't think it's
I don't want you to apologize.
Okay.
I'm clearing it. And you don't have to respond to it. We can carry on with the argument. But I just wanted to clear it.
But I think the argument will actually not take us anywhere because you keep on complaining about not being told about 22.1.
Yes,
22.1.
that's why I'm clearing it.
So,
It's not a complaint.
So the difficulty that I have, and we have actually accepted that with my sister here, that you're not prepared to answer the question that we posed to you. We have accepted that.
Excuse me?
The question that we put to you, you're not prepared to answer it. You've avoided it.
No. Let me. I will never avoid. I promise you, I'll never avoid anything that a court puts to me. I was given it, but sorry, with respect, I say that we are in the 22.9, 22.1 debate. We are in that debate, and that's what I'm debating with Justice Steyn. The second question, or a separate question is, are we properly in that debate? And that's what Justice Mnguni, you put to me. I submit that we are, number one, on the basis of the evidence.
Even though we're still dealing with the civil proceedings.
Yes.
Okay. Because if you read the section, it institute and conduct prosecution. That's what
sorry, with respect.
But anyway,
you're quite right,
let's
Justice
leave it
Mnguni.
at that.
The questions that are being posed to me, with respect, support my argument because of... let me go back. When I come to this court, unfortunately, for the respondents, I am in the territory of the Constitutional Court's Minister of Education versus Harris territory. We cannot get away from that. And the territory of Minister of Education versus Harris is 179.2, as Abrams says in his letter of the 14th of February 2018. That's his power that he relies on. And he may have the power in terms of some other section, but that's not before the court because of Minister of Education versus Harris.
That is if we agree with that submission, Mr. Katz. You're relying,
Yes, yes,
and that's if we agree. So
I'll
we
accept
want
that.
to cover all of the bases.
Absolutely.
If we are not with you on this argument,
Then you have to go into the 22.1.
then we have to go to
Absolutely.
the rest of Section 2.
That's correct.
Mr.
That's correct.
Katz, what compounds the problem is Section 38, actually. It's Section 38 of the NPA. Because at this stage of the proceedings, they can even get out in a counsel from private counsel to come and deal with the matter. If you look at that section,
38.
yes.
Yes, I think. Yes, but, sorry. That helps us. Again, it helps us. It's against the respondents, but the real debate with respect to Justice Mguni is this. Either they have the power, that NDPs have the power under 22.1, or they don't. That's the real, the second debate. That's, if the court rejects my Minister of Education versus Harris point, then the court must go into the question in our submission on the question of whether Abrams had the power under 22.1 or not. From the questions that I'm getting, there's a suggestion, a strong prima facie view, that Abrams did have the power under 22.1, and my job is to convince the court that he didn't have such a power. My learned junior gives me the reference in the record where the point that Your Lordship, Justice Nguni and Justice Poyadrawati raised with me as to why are we ready, and it's 190, pleadings record 190, paragraph 172, which is an answer to 170.
I thought, Mr. Katz, you said you must forget about the answers. Let's look at the interpretation of the section.
Well,
let's concentrate on whether the interpretation is a sensible, practical, interpretation. Let's concentrate on that.
I will concentrate on that the
Yes.
whole day if I have to.
Yes.
Just how much time ever you give me. But you did put to me that I haven't answered your question on why we're ready, and the answer is 172 on page 190. So I do think that it's fair to myself to say that I didn't answer the question. It's 172 on page 190, where Mr. Downer admits the paragraphs under reply and says, following the announcement of Abrams to reject Mr. Zuma's representations, he assigned it to Advocate Noko. That's not conducting in person on any language, and we are ready here for Justice Stein's debate with respect. He handed over the handling of the case to Noko. We are in the territory of Justice Stein.
Yes, thank you. You can-
So, Justice Stein, you put to me, and to my mind, with respect, you've taken the hammer and you've hit the nail on the head by debating with me, does Abrams or does the NDPP have a power under 22.1, yes or no? That is the debate. If he does, then our powers point fails. Not our challenge to Abrams' decision, because we have other legs to that. And we would submit that this point, this 22.1, 22.9 point, is crucial to the future conduct of the National Prosecuting Authority, generally and specifically in this case, on a range of levels. It's not just something that, it goes to the compromise that was the Constitution. It goes to a 100-year history of attorneys general throughout from the Union of South Africa, when the 4 provinces came together, all the way through to 94, 96, when the Constitution was, and this is what this debate is about. And perhaps in my note on oral argument, I was going to refer, Justice Poyadrawati, nothing surprising or weird and wonderful, but just a couple of points that I do wish to emphasize. The one is the first line of the article that I refer to, which is in volume 2 of the bundle, where what your ladyship and Professor Van Zyl-Smit said was this, on page 262, and it's crucial to this debate. And it goes to the 22.1 debate, 22.9 debate.
You said page?
Page 262. And we would submit ultimately, in both Mr. Zuma's case and our case, what you see there in the first 2 sentences is what this case is about. It's written by, the court will see, Professor Van Zyl-Smit and her ladyship. And what they say,
Well, was not a ladyship then, Mr. Katz. Let's just be clear for the record, because you're
certainly-
referring to a ladyship. It was a junior lecturer writing something.
junior lecturer Esther Stein,
in days gone by.
in days gone by. But we would submit that the junior lecturer in days gone by got it right. Then, in 2000. What she said was this: who decides whether to prosecute or not is a matter of considerable significance in any criminal justice system. This is particularly true where prosecutors are allowed a wide discretion, and we emphasize wide discretion because what we're going to come back to say is that Abrams didn't apply his discretion. He had a closed mind. If he had the power, he fettered his discretion by coming to a decision which he was hell-bent on deciding before he decided, and I started this morning's address on that point. He has a wide discretion to formulate policy and to decide whether to apply it in individual cases, which is what happened here. And just to close off that point, I do want to refer to what Brunt J. said in the Freedom Under Law case on the question of deciding to reinstitute where there had been a withdrawal. And that is in our Bundle 1. The case is at 123, but the particular paragraph that I'm dealing with is on 129. It's paragraph 34, and it's the last two sentences. What Brunt J.A. says is the following, and we would emphasize this juxtaposed to your ladyship's Esther Stein lecturer's comment at the time, is as I see it, Brunt J.A. says, the withdrawal of a charge in terms of 6A is final. That's in terms of the Criminal Procedure Act. And there was a debate, 6A and 6B, whether it was before pleading or after pleading. Your ladyship knows the debate. Then the important sentence, the prosecution can only be recommenced by what? And we emphasize the following, a different original decision to reinstitute until, or unless until, the charge remains withdrawn. The point I want to make is this. When Abrams was faced in early 2018, as he says he was, with a decision to, open quote, reinstitute on the basis of the NAFSA ADP decision, he had a different original decision as to whether to reinstitute. That's the point. So when Abrams decided sometime in March, what was he doing? He wasn't thinking, oh, well, status quo ante. He had a duty to make a different original decision.
Now let's pause there. If you're making a different original decision, what is it that the prosecuting authority has to look at? What does the National Director of Prosecution has to do? He has to look at the merits of the case. In other words, what is the case against someone? He has to consider, are there any exceptional reasons why this one will reinstitute prosecution against someone? And ultimately, that constitute other circumstances which impacts on your original decision. Because, you see, Mr. Katz, a withdrawal in the history of the Criminal Procedure Act is never a permanent finding. And that's why all of those things have to be also in the policy.
Correct.
Okay. Had it been 6B, where prosecution had been stopped, then of course someone can...
Under 6B.
Under 6B, when prosecution is stopped.
Absolutely.
It's very different after an accused has pleaded, because thereafter one will be entitled to those pleas in terms of Section 106 of the Criminal Procedure Act.
Absolutely correct.
So
if we're in 6A,
6A1 is always in the territory of something being revisited. There's almost, and I'm very aware of the submissions made by you in your heads to us, saying to us that the policy has been contravened, but you're not arguing the policy now. We're just dealing with the decision.
No.
The original decision.
Sorry, with respect to Justice
You said Abrams,
yes.
and you were citing from the Harams case as to when one can reinstitute.
No, I was making this point with respect. We're dealing with the interpretation of 22.1 and 22.9.
Yes.
And in order to demonstrate... Sorry. I welcome the engagement, because it's important that my arguments, such as they may be understood. And I apologize if they're not understood. We were debating the 22.129 interpretation. And your ladyship puts to me, well, why did Abrams not have a 22.1 power? That's what the debate is. And I was explaining that in interpreting 22.1, we submit that the court has to go through certain interpretive exercises. The first is what I called the powers point. It's a considerable point of public significance. Your ladyship put that in the article. And then I make the point that what we are dealing with in this case is an original, different decision. And your ladyship puts to me, in a different context, what was he required to look at. And for that, I will go to the prosecution policy, which is on page 85, CG9, and the respondents accept that it's binding. But my lady, what I don't want to do, and I will not do, is deviate from debating the interpretive argument, because to my mind, it would be irresponsible of me to not offer the full interpretation argument to the court as to why 22.1, assuming you get there, and assuming you have that, assuming the respondents are entitled to rely on it, is not a power that they were entitled to rely on. So if I may turn back, but I do want to come to your ladyship's question, and I will, and I promise I will. If I promise, I will do so. In paragraph 83 of our heads, Justice Mguni, we make the point, the NPA is the legislative instrument that gives effect to 179 of the Constitution. And just on that, we've included one paragraph from a case called National NPCA versus Minister of Justice. It's on page 25 of our bundle. And as your ladyships and your lordship turn to the paragraph, we emphasize this case is about power, the wielding of considerable power, and when the court considers the location of that power, the width of that power, and how that power is to be exercised, as we've heard yesterday, over and over and again, how it affects rights. We're not in that territory for this purpose, this argument, but the court will consider this power argument. It's a massive power. It's used nefariously from time to time all over the world, as we know. And when the court interprets what the power is about, it'll have regard to the strength and the massive, awesome power to prosecute. Devastates lives, both to and not to prosecute, as we know in this country. There's a particular history of that. But in paragraph 31 of the NPCA, the Constitutional Court says the following: the statutory scheme of prosecutions. The power of prosecution takes three forms in our current regime: the state, statutory, and on certificate knowledge prosecute. The legal framework is established through the Constitution, the NPA Act, and the Criminal Procedure Act. State prosecution, the first category, is governed by the Constitution. And then the important sentence we would emphasize after the reference in footnote 41. The NPA Act gives effect to that power. That's the key. The NPA Act gives effect to this awesome power which destroys lives, protects lives, and has a marked effect on how our society will run when it comes to impunity, accountability, and all the things that we've heard. It's a massive power, and where is that power located? What gives effect to it? The Constitutional Court tells this court the NPA Act, and it's to that act that the court will turn in determining whether Abrams had the power or not. And when we submit, when the court applies common law, constitutional interpretation, canons of interpretive construction, we submit that the clear conclusion that you will come to, that this massive power that is granted generally, as far as this particular official is concerned, is located only and only in 22.9 as far as this particular authority, not in, as Justice Steyn puts to me, section 22.1. And for that, I turn to paragraph 84 of our heads. The section 22 deals with the powers and functions, and of particular relevance is 22.9. The NDPP, and this is the important point, The NDPP does not have a general right to institute or conduct prosecutions for two reasons. First, on a textual and contextual interpretation of 22.9, the NDPP only, and we emphasize only, has the power to institute and conduct where she elects to do so in person. Secondly, a purposive interpretation, emphasize the historical reasons for that, vesting only DPPs and not the NDPP. Section 22.9 must be interpreted in that light. So we go to the textual interpretation. Now, my lady, Justice Poyad-Lawati, it seems, and I can't speak for the respondents, but bearing in mind what we've written here and their submissions in respect of 22.1, they seem to accept these propositions in the sense that they say Abrams didn't have to and didn't, in fact, rely on 22.9. He was entitled to, although he doesn't say so, rely on 22.1. Of course, that hits the Minister of Education versus Harris Point and the National Lottery's difficulty. But on the assumption that they are entitled to make the 22.1 point, I then have a difficulty because it was given for the first time to me, as you say, 8 days ago, 10 days ago. But let's just go on. We talk about, and why it's important is I'm going to ignore up to paragraph 108 because the respondents accept it. It must be taken that the respondents accept, as they say in their heads of argument, that everything that we say up to paragraph 108 is not incorrect. From paragraph 109, there may be a difference. And in paragraph 109, we deal with, in the first decade of the 20th century, the four territories that would later make up the Union of South Africa each had an Attorney General, who were members of the colonial cabinets. Because they were elected politicians, their desire to please the electorate meant that political factors influenced both prosecutorial policy as well as who was to be prosecuted, and we rely on the article. In 1910, when the Union was formed, the position of Minister of Justice was created in the National Cabinet, and each provincial division of the newly established Union-wide Supreme Court had an Attorney General. This changed in 1920. In 1935, there was a change. And then we jump forward to 115. After 114, after more than half a century of political control, substantial independence to the Attorney General's office was restored. In 1992, and we jump to what your ladyship put to me, Justice Steyn, in 1992, the Attorney General Act of 1992 was passed. The Act vested sole responsibility with the Attorney General. The Act also recognized the prosecutorial authority must be exercised without fear or control, and crucially, the minister's role was reduced to that of a coordinator. Section 5.5 required the minister to ensure the reports were submitted to Parliament. The minister had no power to direct. But the nature of the independence created by the Act was of concern to the political negotiators of the Constitution. The ANC in particular pushed for the introduction of a clause in the Constitution that would recognize one unified prosecutorial service in South Africa headed by...
The gist of your submission is that where the National Director of Public Prosecution has taken a decision to prosecute, you want to see the real thing in terms of Section 22.9, the real head coming to court and in person and prosecute.
No, sorry. In other words, what my attorney said to me the other day, what your lordship puts to me, the real thing is this massive federal case where a South African citizen goes and commits war and treason, and this is one of those cases. And if he decides to institute...
Forget about those let's stick to this case. In your submission, once she makes the decision, you want to see her in person in court.
Got to conduct in person.
Is that the interpretation you attach to this section?
No. Sorry, with respect. There are two debates, and I need you...
Let's concentrate on the debate that I'm putting to you now.
The debate that your
debate
that your lordship puts to me is a different debate that I'm having with Justice Steyn.
I want you to respond to the debate that I'm putting to you. Yes.
I accept unconditionally, your lordship, that if the NDPP exercises his or her powers under 22.9, he must or she must do two things: institute and conduct in person.
In person.
That's our primary submission. And
that.
if the court comes to the conclusion that in person doesn't mean what we submit it to mean, and it doesn't mean what the respondents accept it means, then the court will come to that conclusion. But we submit it has a particular meaning, and it means that Mr. Abrams must decide, I'm instituting and I'm conducting, which means that I will sign the indictment, I will delegate where necessary to call a particular witness, but it's my prosecution and I conduct it in person.
He must be present in court.
Well, at least
In this case, because we know that Mr. Abrams is no longer with the NPA, what will happen? He's no longer with NPA.
I'm not.
He must come back and because he took the decision.
No,
What-
the NDPP. No, he's not. It's not Mr. Abrams. It's the NDPP.
Yes, that's why
No,
there is really absurdity in that interpretation.
Absolutely not.
Yeah.
No, sorry, with respect.
Because you say if he must come in person.
No.
It was Mr. Abrams who took the decision.
no,
So the head must. Oh, okay.
But I think you understand the difficulty my brother has with that interpretation.
No, I understand completely.
Yes,
No,
yes.
sorry, with respect. If the court rejects my interpretation of 22.9, well, then we're out of court because he decided to institute and not conduct in person. I accept that. I accept that. I must accept that. If your lordship's proposition to me is that, yes, he has the power in 22.9, which I accept that he has, but he doesn't have to physically appear. He can delegate afterwards, and that's what he did in this case. Then I'm out of court.
He can appear in court and say, so and so, please lead this witness.
But he didn't do that.
Yes, they can't delegate.
But
That's why I'm saying to you,
I accept that.
that argument does not make sense. That's why I'm putting that to you.
Well, I stand by that.
It doesn't make sense.
I say that, well, if it doesn't make sense, two things. One is, as a matter of fact, he didn't do that. Number two, the respondents accept my argument. And perhaps I should read you what they say about the argument.
But why must we be bound by the
We're
heads?
dealing with the interpretation of the section. Forget about what is said in the head. We're dealing about the interpretation of the section.
Yes. Well, we submit that if your lordship takes the view, or if the court takes the view, that the national director has the power to institute and conduct in person doesn't mean him personally appearing or doesn't mean him personally signing the indictment, etc. He's not responsible for the conducting the prosecution, then your lordship will make that finding. And then, of course, we have no beef for that. But that's an interpretation that we would submit. Sorry, with respect, and I say that
We don't have to look at what the parties say. We've
no,
got
I
to
accept,
interpret
of course, no.
But I think you've made your point, and I think we should move from this point.
Except for one thing. Sorry, there's
Because
one,
we don't have to accept, you don't have to accept, so let's
No.
move on.
Now, I do need to deal with. There are two arguments, and they're separate and different arguments. Sorry, with respect to the court, that are being put to me. The one argument, which is driven by His Lordship, Mr. Justice Mguni, is that Abrams had the power under 22.9, which we accept. But the interpretation question is, what does conduct in person mean? And we have a particular view on that, and I'm being put prima facie that my view and my submission is absurd. We would disagree, and we stand by that submission. There is another argument that is made, which is that 22.9 is not his sole power, but he has a power under 22.1. That's the Justice Steyn debate, and it's a different debate.
Yes.
And that's the debate that our learned friends have engaged us with, the 22.1 debate, but they're different.
Yes.
The 22.1 debate goes to the wording of 22.1 itself, contextually, historically, etc. And I would wish to have an opportunity to engage with the Justice Steyn Section 22.1 basket in coming to my conclusion that 22.1 is not a power, but an authorization over other exercises of power. And I wish to have that opportunity.
Yes,
And
you have that opportunity. Can you please
well,
address us?
well, let me make 2 points just to close off that opportunity. The one is, if Justice Steyn's 22.1, or our learned friends rather than Justice Steyn, our learned friends' argument 22.1, it means 22.9 is nugatory. Because one has, if you have a power under 22.1, then 22.9's got no meaning. And that is not an interpretation that the court will engage with without violating the...
Why do you say 22.9 then has no meaning?
Because 22.1 gives the NDPP the general power. He doesn't need 22.9 to give. Why is 22.9 what you can wipe it out? Makes no difference.
No, you making the submission that it then means that there's no meaning. So we want to engage and say, why do you make that submission? Because if one reads the Act, then certainly these provisions follow, and they all follow under that heading of the powers, duties, and functions of the National Director. And it says the National Director or any deputy designated by him shall have the power to institute and conduct the prosecution in any court in the Republic. It means they're not prevented from doing that. You have to read. I think what you do here, Mr. Katz, is one is reading different sections in the Act in isolation, where if one look at them, they all deal with the powers and functions of the National Director, and that's where the original argument and submission started with. Make a comparison to what there was under the old Act, and look then at the new Act. And of course, there had to be a break from the past.
I'm going to make this submission. And I make the submission, I'm going to ask that the court deal with it. In making the submission that if 22.1 is interpreted to give the NDPP the general power, then 22.9 has no meaning. And the court will avoid that construction. And in order to analyze that submission, the court can only do so by having regard to the Act as a whole and the 22 as a whole, not subsections in isolation. And when one has regard to the Act as a whole and Section 22 as a whole, we submit that finding that 22.1 is a source of power, not authority over, but power to, it renders Section 22.9 nugatory. And that is a construction the court will not accept or not adopt. Number two, the Constitutional Court has endorsed, as does the Supreme Court of Appeal over and over, the notion of, I'm going to read the Latin, generalia specialibus non derogant to maxim. Where a power is granted specially in certain circumstances, the court will avoid interpreting the act or whatever it is, the provision or the legislative instrument in a way which gives that repository of special power a general power. So if your ladyship's construction of Section 22 and 22.1 in particular is that there is a general power with the NDPP to prosecute, and we know that 22.9 is a special power, then your ladyship's or the potential our learned friend's interpretation violates the generalia specialibus non derogant maxim. And we submit the Constitutional Court, and I'll give SCA have said it over and over, that is not, it starts off in Dadu versus Krugersdorp Municipality in 1920. It tracks through. That is not an interpretive mechanism that we submit should find favour, the 22.1 time, should not find favour with this court. Now, I've tried, it seems to me from the way the court has dealt with me on this question of the powers point, that I've tried the court's patience, and I'd like to think that the court will have heard my arguments, agree or disagree with them.
We'll digest it, Mr. Yeah.
But let me.
But you see, when you make it over and over and over, then we will lose it. So that's why I suggested let's move on, because we will digest it. So
I suppose repeating a bad argument.
Sometimes lawyers make a good argument, but they interrupt it in between and repeat it, and then we lose the context. Hence, I suggested let's move on. We've heard it, and we debated with you, and whether we agree or disagree.
Justice Luwati, I suppose, when I first became a lawyer, I was told that repeating a bad argument doesn't make it a good argument.
That's certainly not what I'm saying.
But we are. But the point I make is,
No, rest assured, we'll consider
we
and
make a
digest it.
powers point, and we stand by our submission,
Yes.
and we will. The
Yes.
court will have regard to it. The second leg of our Abrams challenge is what we will call the prosecution policy difficulty. Now, in order to determine whether or not there has been a violation or compliance with the prosecution policy, one has to do two things. One has to look at what the policy says and then look at what Abrams did. And if what Abrams did was not consistent with the prosecution policy, which was binding on him, then we would be entitled to Pres 1 and 2 of our notice of motion. And what we submit is if the court has regard to what he did and what he says he did in his affidavit and in his correspondence, he did not comply with the prosecution policy on at least two levels. The first is that we know that in B of item 4 of the prosecution policy, which is on page 92 and 93 of the pleadings record, there are certain directives that are issued to the prosecution authority. It's on page 92. The first part is capital A, stopping of proceedings, and Justice Steyn mentioned to me this morning section 6B of the Criminal Procedure Act, and it would seem to us that that would be where that stopping of proceedings is located. The B part we would submit, and I think Justice Steyn would accept, according to the debate, would be the 6A part. And if there is a restarting after a 6A withdrawal, then what is set out in that directive, we would submit.
Sorry,
If I may just step back, the respondents accept that this version was the binding policy at the time of Abrams' decision. That's not an issue. So one looks at what it is that the prosecution authority, Mr. Abrams, we say didn't have the power, he doesn't say he had the power, etc., but lordship, ladyship was against me on that. This is what he had to do if he had the power. People should be able to rely on and accept decisions made by the members of the NPA. So in 2009, when Mshe decides to withdraw against Tint, the first starting proposition is that Tint or Thales should be able to rely on and accept decisions made by members of the NPA. Let me add to that on the Kurland-Oudekraal propositions. Kurland in the Constitutional Court, Oudekraal in the SCA. The DA challenged Mshe's decision vis-a-vis Zuma. The DA did not challenge Mshe's decision vis-a-vis Thales. And therefore, in October 2017, when NAFSA ADP set aside the decision of Mshe vis-a-vis Zuma, Mshe's decision vis-a-vis Thales stood and was valid and binding. And that, according to Brunt J.A. in the Freedom Under Law case, the only way the prosecution could recommence would be for an original, different prosecution decision to be made. Subject to what we would submit for purposes of this debate is two legal propositions which the Constitution demands. One, compliance with the prosecution policy, and two, rationality. If either of those two legs are present, then we're entitled to Pres 1 and 2. And we submit both legs are present in this case. Abrams did not comply with the prosecution policy in making his original different decision. and it was irrational, and I'll turn to why. Normally, when a suspect or an accused is informed that there will not be a prosecution or the charges have been drawn, that should be the end of the matter. That's the normal case.
Can I ask this? Does Thales accept that the reason why the prosecution was withdrawn against it in 2009 was because the NTPP, acting NTPP then, Mr. Mshe, had withdrawn the cases against Mr. Zuma?
Yes. Oh, that's what they say.
No, I'm asking if you
Well, that's
accept
what they.
that.
For purposes of Plaskon Evans, that's what he said, and the court. The court's bound to accept the reasons on Plaskon Evans. It's final relief on motion.
Yes.
If they say that, then that's what we've got to live with.
Yes.
I wasn't in Mshe's shoes or Mr. Hofmeier's shoes at the time, Mr. Downer's shoes. That's what they decided.
Yes. So, if we have to, I appreciate that at least we still must rely on Plaskon Evans. So, if that is the case, that the SCA now has said that decision was wrong, and there's two legs to my question on the policy, on B.
Understand?
One, that policy says these include, and again we go back to interpretation, because I think your argument is
We're not limited to the 3 bullet points. That's all.
Yes, but your argument seems to suggest we're limited to them
No.
in your heads.
No.
Oh, maybe I misunderstood them, but that's fine.
So
At least that clears one hurdle.
Well, the respondents give 2 reasons, but let me come in our heads on paragraph 138. It says, what I've just read to you, it must be the accused should be able to rely on and accept that decision. That should be the end of the matter. That's the general. Then in paragraph 139, 3 exceptions are made where there are special reasons. Now let's assume for purposes...
I thought I was still asking a question.
Sorry, I do apologize.
Now I've lost track. Where was I?
I don't know.
So the question was, we're not limited to...
Yes, so I appreciated that we're not limited by these
Yes.
3
Yes.
bullets. But we come back to the first bullet, because if we have to accept that that decision was wrong, which the SCA has said was wrong, why should that bullet 1 not stand in this
I understand.
proceeding?
We've dealt with it. We've dealt with it in detail in our heads. And the answer is this. It's a very simple answer. And it links also to rationality. The SCA's decision was in respect of another accused in a different case.
That's why I asked that first question. That should we accept that Mshe's decision was... The first question was, does Thales accept that the charges against it were withdrawn because Mr. Zuma's charges were withdrawn? And you said we must accept that. So if we accept that, then if Mshe's decision was wrong as found by the SCA, doesn't it not link with the Thales decision?
Well,
Because the only reason Thales was withdrawn, and I think it's common cause now, is because Mr. Zuma's charges were withdrawn.
correct.
So if that is the case, so why should we not accept that the only reason, even though it was never challenged or anything, why should we not accept that?
No,
That's why, earlier on I said the unlawful decision of Mshe is intertwined with this decision. That's the point I was trying to make to you.
Well, let me say this. I've got 2 big answers to Justice Nguni's question and Justice Boyola's question. The first is that it is an unlawful, irrational decision by Mshe in respect of another accused can never be, in our submission, a special reason to restart in respect of another accused, even if there was unlawfully a link. Because what it means is this. It means that you have 2 accused in respect of a murder, let's say, and the prosecution under 155 join these 2, 156. And the prosecution say, as they say in our case, it wasn't worth the candle to prosecute Thales. without Mr. Zuma. That's what they say, and that's why Mshe withdrew against Thales.
But let me just try and get some answer on this. Are you saying that insofar as the statement, because you must remember, the statement of Mshe, when he withdrew the charges, he made it clear why he's withdrawing the charges.
In respect of Mr. Zuma.
Yes,
He doesn't mention
he made
Thales.
it clear why he's not. One of the reasons was the abuse of the process. And linked to that, we know that there was a charge which, racketeering, new charge, which is connects accused number 2 to accused number 1, that's what they allege. But I said to you earlier on, that decision to withdraw the charge in respect of charges in respect of accused number 2 was driven by the decision of Mshe.
For number 1.
Yes.
Yes, I've accepted
Yes.
that. I have to.
For
accept
number 1. That's common because you
That's
can't
on
change
evidence.
it.
That's- I
Yes,
have
on
to
the accepted
Absolutely.
rules of motion
Of
proceedings.
civil proceeding, I
yes,
accept
we
that. I
have to accept it.
I have to
Yes.
accept that.
Yes.
Yes, I accept that. But that's not that doesn't that doesn't mean, with respect to the debate, that because Mshe made an unlawful decision in accused X, and his decision in accused Y was premised on that decision, that is in itself a special reason for a status quo. And I'll tell you, let me say
What you're trying to tell us is that these decisions are linked when the withdrawal of the charges is concerned. When they're reinstituted, they are not linked.
No.
Is that what?
Well,
you're
they
trying
are.
to argue?
But let me answer it like this. I think, Justice Mguni, I'll answer that. I'm going to answer on 2 levels. The one is on this prosecution policy issue and irrationality, and I'll come to that. It's not a question of being linked in 2009 and not linked in 2018. It's not a question of that. But the second is this. When it comes to the permanent stay application, which is not part of, which I'm not arguing now, this will loom large. And we would say, how dare the NPA unlawfully withdraw against accused A? 9 years later, it turns out that that decision was unlawful. And they go back 9 years to say, well, we withdrew against accused A unlawfully as NAFSA ADP found, so therefore we just put the status quo back and say, we are an add-on. We are some flotsam floating in the waves. Whatever happens to Mr. Zuma, let's go. Thales, yeah. And if they continue against Mr. Zuma, then they continue against Thales. Not constitutional from a prosecution policy, from a rationality point of view, from a permanent stay. If you reject the argument, then you reject the argument. That's the argument. No accused in this world can be regarded as an add-on, flotsam. And that's what we are
you see,
input.
they've given us reasons why they decided to reinstitute the
Yes.
proceedings.
The
One of
reason-
the reasons is that the evidence hasn't diminished.
Excuse me?
Against Thales hasn't diminished. The evidence against Thales hasn't diminished. That's one of the reasons.
And the argument, Mr. Katz, also loses sight of the fact that there was no permanent decision. You see, the interpretation, while I've made reference to section 6A and 6B, was with reason,
No, it's
is that certainty that any accused person has. You say, how dare they, after 9 years now, treat Thales as an add-on? But the fact is, once the decision was made by the Supreme Court of Appeal that Advocate Moshe's decision was unlawful, how could one treat 2 accused persons differently when the evidence against both of them, seemingly when I understand the answering affidavit of Mr. Downer, still exists and there is still reasonable prospects of success? That would have been irrational, because then one would have treated someone of a higher status in society differently to a corporate individual. Now that would have been irrational.
So with respect, the exact opposite. Each accused is to be determined on its own facts and circumstances. Thales is independent of Mr. Zuma. Mr. Zuma is independent of Thales. And when you consider Ms. Thales, you consider Thales' facts and circumstances, not Mr. Zuma's. When you consider Zuma, you consider Zuma and not Thales. And what the NPA have done is said, bad Zuma, bad Thales,
No, no, no,
good
no.
Zuma,
They say-
good
no,
Thales.
Please, they say they still have evidence that can sustain a conviction. Simple. It's one of the reasons.
But why are they independent of each other? Should we go back to the indictment? What does the indictment say? What does the indictment say?
Well, you know what Abrams did in this case, as far as the indictment is concerned. You know what he did. After he made his decision, which we say he was hell-bent on making in a fettering of his discretion in paragraph 190, he then gave us an opportunity. Wait, no, he didn't give us an opportunity. He took in representations from Thales. He then rejected the representations for one reason and one reason only, and I had come to this in the morning, and it's in his correspondence, and that was because there are reasonable prospects of success. No other reason. Then he says, oh, by the way, I am asking the prosecution team, and you can go back to 22.9 and jump up and down about it, but there is a prosecution team, it's not him, to consider whether to add charges. The court knows that. On a previous occasion, I stood up and I said that Abrams's reference to this adding of charges is in respect of a crime that doesn't exist under South African law. And Mr. Downer stood up and accepted that. Thereafter, Abrams wrote a letter to say that the other open quote charge which doesn't exist
But
is
that has
not going to
already
be.
been put to bed. I think let's not deal with
No,
that.
no, no.
It was dealt with by DJP.
No.
It was before
No,
DJP.
so with respect, Justice Mguni, when it comes to rationality, I'm going to argue that the cumulative effect of Abrams's mistakes, and I'll go through them one by one, demonstrates an irrationality. And that's the argument. But anyway, in paragraph, I'm told, sorry, Justice Poyod, Lawati, paragraph 153 of our heads deals with Justice Stein's point on this question of yes. You see, on paragraph 150, and I was coming to this anyway, your ladyships and lordships put to me, what were the reasons for in 2018 reinstituting the charges? And the court knows from the affidavit. Again, the court's pushed me to the affidavit, and I submit that the National Lotteries Board, Zuma, NAFSA judgment forces the court to look at the correspondence, but let's say we go to the affidavit. Paragraph 80 on 246, he says, my reasons for deciding are 80.1, 80.2, and 80.3. That's what the court invites me to address. And there are three. Yes. They say in 80.1, there were reasonable prospects of successful prosecution. In this regard, I mentioned, in addition to the evaluation, etc., there are two memoranda of 16 June 2005 and 4 July 2005. Before taking any decision, I carefully considered the contents of all three memoranda. When it comes to rationality, I do ask the court to give me an opportunity to take the court in detail to those three memoranda, and I will demonstrate that there are, open quote, mistakes, if I may put it that way, or incorrect directives by those who drafted the memoranda, which Abrams obviously was then directed to, and it causes his decision to fall. 80.2 and 80.3 are what we submit, and the justices, all three of you put to me, what's wrong with those two paragraphs? And we say everything. Sorry, Justice Mguni. In paragraphs 80.2 and 80.3, what the court have put to me is what's wrong with that reasoning. And the reasoning is, because of Mshe's invalid decision, I wanted to restore the status quo ante. That's his reason. Reasonable prox still remained. Mshe's decision fell vis-a-vis Zuma. Therefore, the add-on comes in. That's his reason. Now, if the court finds that that reasoning is appropriate or sufficient, well, then the court will find that. But we submit the exact opposite. It can never be the case that because one accused who is linked in the first instance to another accused withdrawal decisions, and the first decision falls, oh, well, status quo. It's not fair. It's not right. It's irrational on every level under the Constitution. You cannot say, because Mshe's decision vis-a-vis Zuma fell, I then decided, because of that, I'm now going to, let's call it, make an original, different decision. It's an Brunt J has told the world, it's an original, different decision. And then all that Abrams says is, well, Mshe was wrong about Zuma. He linked Thales. Therefore, status quo. It's not an original, different decision. It's an unfettered exercising of his original, different prosecution decision. And it cannot stand on his own reasoning. On his own reasoning, it's irrational. And your court has put to me, what's wrong with that? Everything's wrong with that. He has to make, I'm not going to repeat the words original and different. I'm not going to get better. I'm told, and I'm told to emphasize, that on this point, and I think the respondents accept, and we must all accept, they had sufficient evidence on their version to prosecute Thales in 2005. Why was a decision made original to prosecute them in 2018? Why? Because they acted unlawfully in 2009. And Abrams says in 81.2 on the bottom of page 247, and we emphasize this, I knew, he says, that the tint companies were, and we emphasize the words, in no way responsible for the delay since the charges against them were withdrawn in 2009. So for 9 years, my client sits, and in the normal course, under the prosecution policy, I've read the words, they were entitled to accept, not that the decision was that they would never be prosecuted, but in the normal course, I've read the words, it would be the end of the matter. Normally, that should be the end of the matter. And 9 years later, when they have had nothing to do with the DA litigation, nothing to do with Mr. Zuma, nothing to do with the NPA, Abrams decides status quo. And the court will determine, is that rational? Without, and I want to emphasize this, without giving them the opportunity to persuade him why, without giving them the opportunity, and I want to emphasize this, my ladies, my lord, before making the decision, before making the prosecution decision, not after, before making the prosecution decision, to give Thales an opportunity to persuade him why he should not make the reinstitution decision. And his reasons for that are contained in 81.3 and 81.4 on 248. He says, and I emphasize, different to what he says in his letter, his letter is dated the 14th of February 2018, and I may ask the court to hold 81.3 and 81.4 on 248 and contrast it with what he says on 75 in paragraph 8 of his letter. We submit different, and the court will have to consider why is there that difference between his correspondence and his affidavit. He says in his letter, I note your client's position. This is an email sent to Mr. Dryman on the same day as Mr. Dryman's email requesting an opportunity. I note your client's position, but I'm not persuaded to afford your client an opportunity at this hour to submit representations. Your request is thus declined. Now, we know from the SCA judgments that a potential accused does not have a right to make representations before the prosecution decision is made. Let's accept that. In general, but in particular circumstances, it may be appropriate and it may be required for a rational procedural decision to be made. And we think of Allbutt, we think of DA versus the President in the Menzi Simelane case, and we think of the recent Law Society case of the Chief Justice last year, the SADC Tribunal. Justice Poyo Dlawati, I think, probably knows more about it than I do. But what the courts have said is whenever a decision maker makes a decision of this kind, exercise of public power, not only must it be substantially rational, but it must be procedurally rational. And his reasons for not granting a hearing, which is part of procedural rationality, are contained in his letter, page 75, contrasted with paragraphs 81.3 and 81.4 and 248. And this is what he says in his answering affidavit. And the court will decide, is this rational? We submit not. He says, Justice Poyo Dlawati, I surmise that if the tint companies were recharged then, like Mr. Zuma had done, they could and probably would make representations urging the discontinuance. Let me highlight this. There is a difference in kind to representations made before the institution of a prosecution and those made after the representations, statutorily and in logic. Thales wanted to say to Mr. Abrams, please don't prosecute me. They didn't want to say to him, now that you've decided to prosecute me, please reconsider. And I don't believe he had the power to reconsider anyway. We know that from the Harams decision, Harams DP at the time of 2009, that when the NDP takes a decision, he has no power to review his own decision under 179.5. That's what Abrams did. He reviewed his own decision. And he gives his reason. But anyway, his first point is 81.3. He says, well, if they were recharged, and we know that at that time, on the 14th of February, he had already decided, in his words, in the affidavit, he was inclined to reinstitute. That's what he says to the court. On the 14th of February, when I rejected the opportunity to Thales to make representation, I was already inclined to status quo ante. He says it. Then he says in 81.4, I also thought that if Thales were unsuccessful in their representations, as I had little doubt Mr. Zuma would do, they could and probably would bring an application to court for the permanent stay because of the lengthy period that had passed, as well as the 2004 agreement. So what was in his mind at the time on his version? Not my version, his version. He says, look, I know Thales wanted to make representations why I shouldn't reinstitute, but I thought, well, if I reinstitute, which we know at that time, he was inclined to reinstitute, then he knew, well, if I reinstitute, so be it, because then they can make representations to him, which we did. He considered them probably unlawfully on the Harams DP decision of 2009. But in any event, even if I rejected them for the second time, they could go to court because of the lengthy delay. So what was in his mind? That there was a court challenge waiting in the wings about this lengthy delay. So therefore he says, because of these potentials, I don't give them a hearing. Before I make my decision, this awesome power that he exercises, 9 years, on his version, we were in no way responsible. And he says, it doesn't really matter. You're an add-on. The Supreme Court of Appeal said Mshe was wrong about Zuma, therefore I'm inclined to go with the status quo ante. And the court will determine, is that procedurally rational? And we submit not.
We'll come back at
Yeah, and Mr. Katz, I think you still haven't answered my sister's question regarding the indictment, because when she dealt with the Mshe question and the invalidity of his decision, she went back as to Thales' position, and she asked you to look at the indictment. And you've dealt with other issues around the indictment and the finality of the indictment. But I think what really is important is to look at the alleged charges contained in the indictment and what it relates to. Because but that is, I think my brother has said we will now take the short tea adjournment, but that will deal with another aspect.
May I just ask to help me, if I may, or to help the court to help you? As far as the indictment is concerned, what specific aspect in relation to the indictment is it, Justice,
To
for
the
your
charges.
that you wish me
To
to
the charges.
Yeah.
Because you seem not to accept that the Thales is interlinked, so to say, with Mr. Zuma. So I want us to look at the charges.
Well, yeah, I understand.
Rules of conduct
To take
of
the
the two, yeah,
contention.
of the
No,
two.
I
Yeah.
just want to let's just come out now. Sorry, I need to I don't want
Come
to waste.
back at
We need to take the team.
I don't like this conversation happening. Yeah, they think it's a joke, this guy.
I think before the adjournment, it was suggested that I hadn't answered Justice Poyod-Lawati's question on the issue of whether, bearing in mind the indictment is the same and interlinked, what was irrational about Abrams' status quo ante decision. And I'm going to attempt to answer it like this. On page 91 of the record, there is a portion of the prosecution policy which we submit on Mr. Abrams' correspondence he failed to consider, and therefore, even if the indictment was the same, identical, interlinked, he fell foul of his duty to act rationally. And it starts with, there is no rule in law stating that all the provable cases brought to the attention of the NPA must be prosecuted. On the contrary, any such rule would be too harsh and impose an impossible burden on the prosecutor and on a society interested in the fair administration of justice. When considering whether or not it will be in the public interest to prosecute, prosecutors must consider all relevant factors, including, and then the bullet points, and the last one on the page is of relevance, which is that whether there has been an unreasonably long delay between the date when the crime was committed, the date on which the prosecutor was instituted, and the trial date, taking into account, etc. Now, what Mr. Abrams does, just my ladies and lords, on page 125, he tells Mr. Dryman why it is that he has rejected the representations and therefore continuing this institution of the prosecution. And his only reason, and it's the only reason that you may have regard to, is in paragraph 2. And I say the only reason, again, I refer to the Zuma versus DA 2018, volume 1, at paragraph 24, on page 33 of the bundle. After careful consideration of the matter, I'm of the view that there are reasonable prospects of a successful prosecution against your client, full stop. Now, when it comes to not the substance of his decision, Justice Poyod-Lawati, his process of reasoning, he does not say that he took into account, although he says it in the affidavit, the lengthy delay or how it might affect the types of issues that the prosecution policy talked to. And for the proposition that the substantive irrationality is to be determined separately and differently from the procedural rationality, I turn to the Law Society case, which is in our heads.
Before you get to the...
Understand your argument, please help me. You're saying he ought to have set out, the reasons. You refer us to paragraph 2. He ought to have set out what he considered to arrive at the decision that there are reasonable prospects of success or prosecution. Is that what you're arguing?
I'm arguing that in order for the court to find that he adopted a rational process, one would have to look at how that process that he adopted, what did he receive and what is his response to it?
Says it out in the affidavit.
Mr. Katz, sorry to interrupt my brother, but we don't know what he received because you see, you're again isolating paragraph 1 and paragraph 2, which says your representation submitted via email dated this refer. So there are the representations made to him. After careful consideration of the matter. Now that must include those representations you have made to me and any other information I have had before me. I am of the view there are reasonable prospects of successful prosecution against your client. You see, we don't, you without those representations, because those representations informed his decision. Do we have those representations?
Excuse me?
Do we have those
No,
representations?
but what you do have, sorry, with respect, is in our founding papers an explanation as to why that conclusion, bearing in mind what the representations provided, constituted irrationality. And that you will find on pages 42 and following, where, if I may just, the court could flip through it. And the court will find that all the way through, there is the question of what I'm going to call the features of our permanent stay application dominating. That is, the representations didn't deal with the substance of the charges. They dealt with the fairness of what was being imposed upon Thales. And for that purpose, perhaps maybe I should just hand up paragraph 64 of the Law Society case of the Constitutional Court, where you may disagree with the notion that his reasoning was substantively fair or legal, but not procedurally. May I read paragraph 64? Because I have mentioned this point, and it is in our heads, but I do want to just emphasize. The proposition in Masetla might be seen as being at variance with the procedural irrationality laid down in both Albert and Similani, but it is not so. And I want to emphasize this. Procedural fairness has to do with affording a party likely to be disadvantaged the opportunity to be represented, etc. Now I want to underline the following words. Not so with procedural irrationality. And I started this morning by saying our Pres 1 and 2 on this third leg, the irrationality leg, do not deal with procedural fairness. And yesterday we heard many arguments about violation of rights, etc. We're not talking about this in this context. We are talking about the latter is about testing whether or ensuring that there is a rational connection between the exercise of power in relation to both process and the decision itself and the purpose sought to be achieved. And what we have here on Mr. Abrams' own say-so in his affidavit is this. Status quo. Justice Poyal-Blawati, you said to me, what's irrational about status quo ante when there was a link between...
No, I don't like it when you are not putting my question properly. I said, if the 2009 decision was taken was taken after the withdrawal of the charges against Mr. Zuma, that is Thales 1, and we accept that that decision for Thales was linked to Mr. Zuma's one. And now the SCA has found that the shared decision with regard to Mr. Zuma was wrong. Why is it wrong now? Because
No, I understand.
no, I don't want irrational, because I haven't come to that. I'm saying wrong in the sense that I'm saying wrong for now, because I think we'll come back to irrational.
No, sorry, I'm going to argue. May I try? And I'll do my best.
And then something which we haven't gotten yet to, and I said, because you said Thales should not be an add-on, and I said let's go and look in the indictment and let's look at the charges. What does it say, so that we can understand whether one is charged independently of the other, or one is linked because of various conducts towards the other.
May I try and answer the first question, which is what's wrong with the reasoning, and the second question is the indictment and the link. As far as the first question is concerned, the wrongness. if I may just describe the wrong decision to constitute substantive irrationality. So it's wrong or right because it's substantively wrong or substantively rational to make the decision that Abrams decided. And I have to accept, Justice Poyet-Lawati, it may be, and I don't make the concession, but it may be, and because that's not our case, it may be substantively rational. In other words, nothing wrong with reasoning it the way he reasoned. So that's my first answer. So you ask me what's wrong, and I say, in the language of that word wrong, I'm making no submission because I accept, for purposes of argument, I don't concede, but I accept for purposes of argument there may be nothing wrong substantively with a decision to link the status quo decision. I'm making a different argument, which is this. If he makes that process of logic, that reasoning, he says, Zuma withdraw, I then withdrew against Thales. The Zuma decision was, Mshe's decision against Zuma was set aside by the SCA in October 2017. Therefore, I reinstitute, I make an original different decision versus Thales. There may be nothing substantively wrong with it. Maybe. That's not our case. Our case is how did he make that decision? And what he did, as I understand it, and what he says he did, is it was a knee-jerk, hell-bent status quo decision. He fettered his own discretion. What he did not do is say, well, I have this chain of events, Zuma, Mshe, Thales, Mshe, October 2017, now I have to decide Thales. What do? I can't knee-jerk reaction. I have to apply my mind procedurally. But what about Thales? How is Thales different now?
He tells us how he arrived at that. He says, he, after carefully considering the matter,
Which
he
include the
then
representation.
decided that both accused 1 and 2 be charged.
No.
After careful consideration of the matter. And that he explains to us what he considered in his affidavit.
He does. Sorry, it's 81.3. It's 81. It's 80.1, 2, and 3. His reasons are what he says in 80.1, 2, and 3. I accept that. And what he says his reasoning is what your Ladyship Justice Poyet-Lawati put to me. That was his reason. I have to accept that. I've made the point to Plascon Evans beforehand. I accept that, Justice Mguni. But procedurally, what do we demand would be rational from a procedural perspective? He would have had to have done the following in our submission. He would have had to have said, I am now status quo anteing Thales because of the October 2017 SCA decision. That's what I'm thinking of doing. He says it. He does say it. He says, look, Mshe made a bad mistake. Thales got the benefit of it. Mshe's decision was set aside. Now I'm considering what should I do about Thales. And his prima facie view is status quo. I accept that. And your Ladyship puts it to me, and I must live in that world. But the question that puts to one is, what did he look at? He says what he looked at, 80.1, 80.2, and 80.3. And the question that Justice Poyet-Lawati, the court, will look at on the law society reasoning is, what did he look at in relation to Thales? Nothing other than what he says. And what does he say? There were reasonable prospects in 2009. They got the windfall of the unlawful Mshe decision. Therefore, 8 years later...
But that can't be, Mr. Katz. We're getting back to the plain and simple reading of this letter. It can't be. He considered the content of the representations.
Yeah. Of?
The representation.
No, I'm talking about, sorry.
No, let's go back to that letter.
On 125.
On page,
If
yes.
you read at 125,
Yes.
the letter is actually in the present tense.
Yes.
I am of the view that there are, not that there were reasonable prospects of
accept that.
success. There are reasonable
I accept
prospects of success. It's his own decision.
Yes, I accept that.
And that is done in your representations, under consideration of the matter, and then I reach the conclusion.
Sorry, I was talking about...
So this deals then with your issue as to, you say procedural rationality would include, what did he look at? Well, he tells us what he looked at.
Sorry, I was arguing something. Sorry.
Yes.
I think I'm understanding maybe I'm understanding what you're trying to say. I hope so. You are saying from his response, he does not seem to have taken into account what Thales is saying.
No,
Yes.
no, sorry.
So what is
So if I may turn to the record, page 247. This was the decision in March 2018, not July 2018. This was the decision to reinstitute, which is subject to paragraphs 1 and 2.
247.
Page 246 onto 247.
236.
No, 246 of the record.
Yes.
246, yes, 246. Sorry, paragraph 80. This is what he says he looked at. He says he looked at, and this is, sorry, he uses the words, my reasons. So now we know what his reasons are. And the reasons are contained in paragraph 80. Those are his reasons. And what the court will do in our submission is interrogate whether those reasons satisfy what the Constitutional Court said in the Law Society case are procedurally rational grounds for coming to the decision to reinstitute. Not substantively, because substantively I say we haven't made out that case. So I accept Justice Boyd-Lawati that perhaps, for purposes of argument, it might be okay to do what he did. I'm not conceding, but procedurally, what did he do? He says there were reasonable prospects of successful prosecution. He looked at the three memos. 80.2, the prosecution would not have been discontinued, but for Mshe's invalid decision. And 80.3, I wanted to restore the status quo ante. Those are his reasons. Now, they may be substantively rational. I've made this point. But procedurally, at that point, we know because he told us, and it's before the court, he didn't know anything about Thales in 2018. He tells us that. He refused to let Mr. Misdraman make representations. So he made his decision 9 years after the event on the knee-jerk reaction. SCA.
But that, how can that be? What do you see? You can't just look at 80.2 and 80.3 because what I see from here is that there were three memoranda, and one of them is a very recent memoranda that was given to him. You can't say now he's making a decision on something that was 9 years ago, Mr. Katz. Surely that's factually not correct.
No. In the recent memoranda,
Yes.
that memoranda related to Mr. Zuma, and yes, it contained elements about Thales, but
Yes.
that memorandum was in response to Mr. Zuma's representations at the end of January. That's what he looked at. So he looked at what Mr. Zuma said. He looked at what the prosecution memoranda from 2005, the two. What did he know about Thales in 2018? What did he know? Nothing.
So are you saying, because I think it's important for all of us to understand it, are you saying he made the decision before he got the representations from Thales?
Yes.
That is why you are saying procedurally,
In the circumstances.
in the circumstances, it was incorrect.
In the particular narrow circumstances. And his reason is, linked to 80. One can't think away, with respect, Justice Steyn, 80.2 and 80.3 as if they don't exist. They exist.
I'm not saying that, Mr. Katz.
No.
I think you also cannot exclude 80.1.
No. There's a series of cases where, in the labor context, for example, an employer fires a person for 5 reasons. It's ended up in the Constitutional Court case called Platinum Rust. And it turns out that 2 of the reasons are bad, but 3 of the reasons are good. The Constitutional Court says the decision doesn't stand, it's vitiated. And my point is a simple one. From a procedural rationality perspective, 80.2 and 80.3 are bad, without reference to what Thales might have said. It's not procedurally rational to say, sorry.
Why is that important? Because in 2009, when the charges were withdrawn, I think it is common cause that they said prior to the withdrawal of the decision, they had a good case against Thales. So when he then decided to prosecute, he looked at that and all of those factors. That is why should it be procedurally wrong for him to have done that, even without Thales' representations at the time?
Right. We say the following. That's the nub of the difficulty.
Yes.
We say the following. In 2009, a decision to withdraw against Thales is made, let's call it a separate and self-standing decision. Yes, it's linked to Mr. Zuma's decision, but it's separate and self-standing. It's a choice that the NPA made. They could have decided, we're withdrawing against Zuma for the reason that we withdraw against Zuma, but we're continuing against Thales. They had that choice.
But you see how it's all interlinked. That's why we're not going to move very
Well,
fast on this issue.
No, I understand.
Because you have to combine both substantive and procedural.
Well, if the court finds that it's
from your own argument, I think.
No, I accept. If the court finds that it's procedurally rational to say it's all interlinked, and therefore, when the decision to withdraw against Zuma falls because of the link, therefore status quo ante, then I have to live with the court's decision. But we submit that in the particular circumstances of this case, it's not procedurally rational to regard 9 years later an add-on when there is no reason why for 9 years, from 2009 all the way through to 2018, there was available evidence on the NPA's version to prosecute Thales, and nothing happens for 9 years. Nothing. Abraham says so. I knew that Tint were in no way responsible for the delay since 2009. How could it be, in our submission, rhetorically we ask, rational procedurally to ignore what Thales says, despite them wanting to give an opportunity to argue, to say, add on, status quo, knee-jerk. SCA says Mshe vis-a-vis Zuma's bad, therefore there was a link, therefore Thales comes back in the box. We submit it's not procedurally rational to do that without at least saying to Thales, as an example, we're intending to do this because of those reasons, substantially rational. How would it affect you?
But
Not procedural.
and this is my last question,
Yeah.
I hope, on this point. Isn't that tantamount to saying, I'm not going to charge this accused until he tells me his own representations? Once you finish all your investigation, you decide you have a case you want to prosecute. But I can't prosecute because I don't know what they want to say.
If the court finds,
Is that wrong?
I'm answering straight. If the court finds that in these circumstances, then the court will be saying, in our submission, it would never be required of the NPA to ask a potential accused whether they have anything to say.
Can I approach it in this angle? Maybe
Yes, sir.
it will help us to reach our destination quicker. We have a situation where the charges against Thales were withdrawn because of the unlawful decision of Mshe. The charges were withdrawn because the decision to prosecute was linked to that decision of Mshe. We accept that. We also accept that there was, of course, litigation between the DA, the NPA, Mrs. Zuma as well, which was carrying on until it came to an end in January of 2017, if I'm not mistaken. October 2017, yes, October 2017. In light of that, was it possible for the NPA to reinstitute the proceedings against Thales?
Substantively, yes.
Why do you say that? Because the decision to withdraw was linked to the unlawful decision.
No, so let me take that. I say substantively, conceptually, yes, conceptually. But that
Yes,
isn't our case.
if we accept, we've already accepted that it was linked to the decision of
Yes, no, I
Mshe.
accept that.
So was it then possible, until a determination is made on that decision, on Mshe's decision, on the lawfulness or otherwise of Mshe's decision, was it possible to prosecute Thales?
I'll give you another. Can I debate?
Yes,
Possible. You asked me the question. Possible. Yes.
Yes.
But I want to. Let's assume for a moment. In 2010, the decision by Mshe vis-a-vis Zuma was set aside.
Yes.
And in 2010, the NDPP or the acting Jibba, whoever it was, came to the decision, I now have to consider the Thales issue because of the link, and I decide in 2010 to status quo ante. Procedurally, it may not have been, from a rational perspective, be required and then to say to Thales, what do you say?
It will be any rational decision to say, to
In
prosecute.
2010. But 9 years later, in the circumstances, in the particular circumstances when Thales had nothing to do with the delay, we submit that it's procedurally irrational to make the decision, which may be substantively rational, without at least opportunity, when they've asked for the opportunity.
And you say your authority for that?
Albert,
submission?
Simelane, and Law Society.
This is despite the concession that the two
2010.
decisions were, are linked.
Yes.
Okay.
Excuse me. Yes. Now, may I just have a word with my junior? I just think
Yes.
that's important. Yes. 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 What Ms. Adhikari...
Yes, sorry.
So, what Ms. Adhikari reminds me, and I do want to emphasize this, it's not the NPA's case that they could only try Zuma and Thales together. That's not their case. Their case is there was a withdrawal against Zuma, and therefore it wasn't worth the candle, in Dana's words.
So what
Because
does
of the
that
charge,
mean?
nature of the charges.
In light of the charges, and that's why we said the nature of the charges are so important. Please consider that before our tea break, as to the nature of the charges.
A part of my address is that the charges, for example, I wanted to address two issues and I've got stuck in the one, but the second I'll come to. The nature of the charges for our purposes, for purposes of argument, or let's say identical, they're interlinked. Let's accept that for purposes of the argument. It goes to substantive rationality. It doesn't go to procedural rationality. And that's what that's why the Law Society case, Albert and Simelane are so important. And I reiterate, not so with procedural irrationality. The latter is about testing, etc. And how could Abrams legitimately test what he had to test without, in the circumstances of this case, saying to Thales, what do you say? I'm inclined to prosecute you because of the link and the October 2017 SCA decision. I'm inclined to, and I think I'm going to. But before I do so, do you still exist? Is Tetar dead or alive? Where is he?
Why must he make that? Why must he make those inquiries?
You've got to tell us where
Okay,
he
well, I'm
is.
going to leave it. I've made the point
Yes.
that it's procedurally irrational not to have done so in the circumstance. What happens if it was 20 years later?
Does it matter?
But
Why?
then we will start dealing with matters of prescription. Mr. Katz, I think
Mr. Judge.
where we and I'm going to sound like a scratch record, and I also want to move away from this point. But you see, the representations made to Abrams is very important. Those representations are not before us. Because if you want to say to us, procedurally, he ought to have considered, because Tetar is no longer alive, as has been said in Mr. Zuma's affidavit, or if it is a matter of the certain evidence that you insist using against us has been destroyed, that is really the issues that become important. So when you want to rely on this letter of Mr. Abrams, then we say you have to look at it together, the whole content of that letter. And that brings us then to the procedural rationality.
Well, with Justice Stan, if one turns to page 49 of the record,
Yes.
there's a piece about,
That's the unreasonable delay.
no, it's the violation of the prosecution policy. Page 49
49 of the record.
of the record.
Is starts off at the top with unreasonable delay.
My
Maybe it's
paragraph
marked 53.
21
It was the original 49. Yes.
Sorry, so not the
You
not
want
the,
to you want me
the
to
record
look at
the record 49 as opposed to the
Yeah.
affidavit 49.
Some of them still have. Yes.
It says Thales was never advised, nor does it appear from that its prosecution was halted in order to allow the police. So we know that they're all common cause. And then we say for this reason it was procedurally irrational, etc. The respondents are invited to explain why the decision to withdraw against Thales was taken in 2009, and now we know, and why it was taken to reinstitute. And so here we have it. Okay. Now the question that I want to pose and submit.
What do you refer to as here we have it? Are you referring to this is the representation?
This is the answer to the representations is CG 14, which is attached to our.
No, that's the answer.
Yes.
You see, the representations, however, are not here. And if you say, and this is what Abrams says in his letter, he says, I've considered those representations, and then he says further, and it's clear that this relates to the matter, and then he informs Mr. Dryman of his decision.
Yes, that's right. Now, on page 58 and 59,
Yes.
and all of this was either not before Abrams when it should have been, and no fault of Thales. Mr. Abrams' rejection of our representations dated 14 February 2018. And that's where the problem was. He refused Thales the opportunity to make representations because, and the court knows why he did so, he tells us. And one says, in paragraph 258, to the best of my knowledge, Moineau has Alzheimer's, not in a position to provide assistance. Tattard resigned in 260, resigned from Thales in 2011. Tattard in 2009 said he has no intention of returning to South Africa. Tattard, etc. 267. Or let's go to 266. France declined to prosecute Tattard or send him to South Africa because his conduct in South Africa at the time did not constitute criminal conduct in France. Mr. Perrier, Mr. de Jamarant, to whom reference is made, are not available to assist Thales. Thales has no means of compelling the court to provide any information or assistance in defending the charges. From a procedural rationality perspective, we submit, bearing in mind 9 years, our client is a corporate accused, we submit that the rational procedural process to adopt would have been at least saying to Thales, are you in a position to defend the charges now, bearing in mind.
Why? Yes. Why? Why must you ask an accused, are you ready to defend me?
So
Why?
if your ladyship puts to me, why?
Yes.
I am saying because of the facts and circumstances. And if you come to the conclusion that it was procedurally rational to reject Thales' request for representations for the reasons articulated in the letter, which we submit don't pass muster, which is on page 75, and you say that we withdraw in 2009, and in 2018 you status quo ante without giving that person, the corporate accused, an opportunity, if you find that rational, procedurally, then we submit that there will never be a time, never, and we emphasize this, when it's procedurally irrational to not afford a particular long delay accused an opportunity. And this is classically the type of circumstance which would demand procedural rationality, give the corporate accused a hearing on this issue.
So we must make a distinction now between a corporate accused
No.
and an in.
No.
No, but what is the difference between Thales and Mr. Zuma in this instance?
the question that you posed to me is why was it procedurally irrational to not offer Thales the opportunity as per page 75? That's the question. And I'm answering it like this. In the particular circumstances and the facts of this particular matter, which includes a corporate accused, long delay, not because of their fault. They had nothing to do with the delay. All of those features, they had a good case in 2009. They could have prosecuted Thales in 2009. They chose not to. Not that they had to not. They chose not to. 9 years later, they have to now make a fresh decision because of an SCA decision in respect of another case, which is linked. And the question that you posed to me, why is it procedurally irrational in those circumstances to not say to Thales, well, what do you say? We're intending to prosecute you, bearing in mind the SCA's decision. And we would have said, well, our four no longer exist, they're all dead. We could have said anything. But how could it be procedurally rational to ignore the circumstances and the facts of a particular accused, whether it be a corporate accused, an individual accused, the highest or the lowest, bearing in mind these facts where they took a self-standing, interlinked, but a self-standing decision to not continue the prosecution against Thales because of some other decision in respect of Mr. Zuma. 9 years later, 9 years, Thales has nothing to do with the 9 years. They decide, the SCA said we were wrong in another case, linked, so therefore we status quo ante, without giving that person. Those facts and circumstances in our submission demand from a procedural rationality perspective at least the opportunity to be. And if you say no, I'm wrong, then we submit there will never be procedural irrationality in the original decision of the type that Brunt J.O. spoke of 9 years after a withdrawal in the kinds of circumstances that we have today. Never, and we emphasize that. Now I do want to turn to, excuse me, the facts of the three memoranda which Justice Steyn, you referred to in the debate with me. Those are SKA 20, SKA 24, and SKA 25. Now, SKA 20 is on page 340. And we've made this point, I do want to emphasize it. These on 340 is the first memoranda, that's SKA 20.
That's the one in 2018.
23rd of February 2018.
Yeah.
Now, that memoranda deals with and was geared, as the subject of the document says, response, top of the page, subject, response to representations received from Mr. Jacob Zuma, Mr. Zuma and his legal team on 31 January 2018. And in the document, which ends on page 390, on 389, there's a recommendation. The recommendation is this: the prosecution recommend that the representations of Mr. Zuma should not be acceded to. The prosecution against Mr. Zuma and Tint should be reinstated forthwith. Now, just technically, and I offer it to the court, I don't want to spend a lot of time on it. At that point, there was no prosecution against Mr. Zuma to reinstitute. The SCA had already done it 18 months before. So the prosecution team got it wrong technically vis-a-vis Mr. Zuma. Number two, this document mentions Thales without reference to Thales at all. but it only has reference to what Mr. Zuma put in on the 31st of January. And I asked the question rhetorically. Here's a document consisting of 52 pages, a long document, dealing with Mr. Zuma's representations. And they talk about Thales all over the place, without Thales being before them. How can that be procedurally rational?
I think so.
And it's
Mr.
again,
Katz, no, seemingly this is the last time I'm going to refer. I thought when we dealt with the legitimate expectations to make representations, that Harum's DP dealt with that in the Zuma case. You see, when it was argued before the court in front of Judge Nicholson that Mr. Zuma expected to be heard and given the opportunity legitimately to make representations, the court dealt with that. And I think that was in paragraph 80 of the court's judgment.
That's right.
So, and what was said is very important. Is whether it's based on a practice, and this is why my sister asked you: can an accused expect that, and mustn't a corporate accused expect more than any other accused, than Joe Soap that stays in New Germany and has been charged with fraud or with racketeering?
May I
So that gets to your procedural rationality, because if that is true, in every matter where there is a delay, there ought to be a legitimate expectation, and that can't be.
Yes, you've asked the question, now let me answer it
Yes.
directly. Paragraph 64 of the Law Society case deals with it head on. And when the Chief Justice says not so, he's effectively saying not so to your question. Because what he says is this: the proposition in Masetla might be seen at variance with procedural irrationality, but it is not so. Procedural fairness, and I emphasize, Justice Steyn, procedural fairness, which is what Harum's DP was talking about in that case. And your ladyship put it to me: legitimate expectation is procedural fairness. We're not talking about procedural fairness. And that's what Mogoeng CJ goes on to say. But it is not so. Procedural fairness has to do with affording a party like Thales, as for example, or Mr. Zuma in that case, likely to be disadvantaged, the opportunity to be properly represented and fairly heard before the adverse decision is rendered. And that's what your ladyship puts to me. But what does the Chief Justice respond to your ladyship's question? Not so with procedural irrationality. It's a different test. It's different in kind.
I think it's whether it's labeled procedural rationality.
No.
It is your reliance on the case is dependent on us making the finding of that procedural irrationality.
So, your ladyship puts to me, and I have to deal with it. Harum's DP decided that Zuma did not have a legitimate expectation to make a representation. I have to accept that. That's procedural fairness. Our case is not about procedural fairness. It's about procedural rationality, which is different, the Chief Justice tells the court, tells the world. They're different concepts. Procedural fairness goes to the right of the affected party, so the Chief Justice says, to be properly represented and fairly heard before the decision is rendered. I'm not arguing for that. I have never, the founding papers, the replying papers, our heads of argument, my oral argument does not talk about procedural fairness. And that's what your ladyship, Justice Steyn, puts to me. Legitimate expectation, Harum's DP from 10 years ago. This is a different case. It's about procedural rationality. And there he says, not so with procedural rationality. It's a different test. And if you reject the difference between the tests, I'll have to live with it. But it's different. It's a different kind of test. It's different in substance and it's different in practice. And if the court says, well, Thales don't have a right to legitimation, Harum's DP, I have to live with it. Of course they don't.
Can we move to the next point, please?
The next point is SK24. Which the court will find on 403. It's a report dated 2005. Again, this is the second report that Mr. Abrams says he looked at. That's in 80.1. And it leads to various conclusions. So I do want to emphasize, we do deal with it in detail in our reply, whatever. But if we just jump to 492 on SKA 25, and we would emphasize this. This is what Mr. Abrams says he looked at. Perhaps at the top of page 493, the court might make an annotation that this confidential report, which is the legality of charging tint, and whether tint should be added in the prosecution of Zuma, is dated 4 July 2005. 4 July 2005, this is what he said. Paragraph 1. A final decision relating to the prosecution of tint must be made urgently. Now we're talking 2005, and Abrams is looking at this in March 2018. Urgently. So 2005, 2018, and now they must make a final decision urgently. It is inconceivable that there could be a third prosecution after Zuma's. The choice is thus either to charge tint, 2005, Justice Poyet-Lawati, now or never. So Abrams looks at a memo that says to him, NDPP, or whoever you may be, decide whether to charge tint now or never in 2005. Make the decision finally and urgently. And in 2018, he says yes. And I asked the court, is that procedurally rational? That when he is told by his prosecution team in 2005, now or never urgently, and 13 years later, he knee-jerk reaction add on. The court will decide, is that procedurally rational?
But he was not charged after that.
Excuse me?
But what is it not charged after that? And the matter was eventually struck off the road.
I'll leave it.
But why?
I'm going to leave it. I'm going to leave it. Because that, it's not, we submit, it's not procedurally rational.
No, but that it is irrelevant because they were charged and they appeared before Mr.
Yeah, and it was struck from the
matter was
road.
eventually struck off the road.
Yes.
You're talking about 2006.
Excuse me, 2005. Yes.
2006.
By
when the matter
2006 they
was
were
struck off
charged.
the
If the
road.
court finds that it was procedurally rational for Mr. Abrams to look at a document dated 2005, which says urgent now, never then, and to say in 2018 it's fine, I'll leave it at that. The court knows my submissions.
Thank you. Thank you.
Now, I do want to just touch upon some final, what I'm going to call odds and bobs. And the reason I call them odds and bobs is because of a case called Ompad. It's a case of Olsen J. with another one of your court's brothers, which says the following: where there's a challenge to a decision, and there are numerous blips and blobs or irregularities of some kind, the court.
Where in your head are you?
No, it's not in our head. It's a general proposition of law.
Okay.
I'll give you the reference in a second. But what it says is this. Goes back to a case in 1916 Cape Division. The court is entitled to look at the cumulative lapses. And one doesn't just look, there are 10 irregularities, none of which in and of themselves vitiate. But each of them cumulatively suggest it's not reported at, I'll give it to my learned friends, 2014, it's ZAK ZPHC 29 at paragraph 26. Maybe I'll just read. In my view, these are...
No, wait, you can't read something to us if we don't know where to find it.
It's paragraph 125 of our note on oral law.
Yes. Is this in
So this
125 in your new note?
what he said is in Olson J says, in my view, these irregularities in the proceedings in the magistrates court on their own justify an order reviewing. But then the important sentence, if any of them was not on its own grossly irregular, cumulatively, and what I want to debate and suggest is then one has a look at the papers as a whole and looks at what Abrams did. He puts a foot wrong here, a foot wrong there, and each of them, the court might find, do not demand that his decision be set aside because none of them are such that they were vitiating regularity. Then I'm asking the court to take all of his lapses, his missteps, his speed wobbles, and cumulatively consider them and say whether, as a global issue, they demand a vitiation. And I start on CG8, on page 83. CG8 is a newspaper article, and it's mentioned in the affidavit. But I'll page CG8, 83. What happened was, the court knows, there was much. It's on page. It's CG8 on page 83, and it's referenced in the founding affidavit on page 39, paragraph 163. What happened was, the court recalls that in October 2017, the SCA set aside the Pres Zuma decision, and Mr. Zuma put in his representations at the end of January 2018, and many civil society got all excited about the Abrams decision as far as Mr. Zuma's representations are concerned. Thales are not in the picture at all at this stage, other than the Dryman-Abrams interchange. And what the NPA say on the 14th of March 2018, and it's paragraph 163 on page 39 of the record, the NPA spokesman, Mfaku, says, Abrams will consult with the various parties involved in the case to inform them on when he will make a decision and will then make the public announcement on that date.
Is that correctly quoted?
What should we read into that? What do you want us to read from that?
This is what I want you to read.
Yeah.
He did not consult with Thales at all.
But we're relying on a journalist making this statement that Mr. Mfaku said it.
No, you're relying on affidavits. Paragraph 163
Yes.
on page 39.
Yes, but let's look at paragraph 163. How does this now make what Mr.
Well,
Mfaku
let's see
said
what
here?
the allegation-
I thought again, if I look at what newspaper articles say, it is the view and the facts as displayed by a journalist.
Yes.
Yes.
In paragraph 163 on page 39, this is what the deponent says in an affidavit. On 14 March 2018, the NPA spokesman publicly indicated the NDP was going to announce the outcome of Mr. Zuma's representation shortly and then consult with the various parties to inform them on the date. A copy. That's 83. The answer one finds on page 191, paragraph 173, where the answer is, I admit the media article contains what is stated in this paragraph, but I've been unable to locate it. So it's admitted that the article contains what it purports to contain. Whether it's true or not is a different matter. But there's no denying that that's what he said. That's what it pleads. It's pleaded in paragraph 163, this is what the newspaper article says.
Yes. So what is the importance of that in this case? That's what
This
you want
case?
to know. Yes.
No, but I ask a different angle because it takes us back where I thought we have moved from. It takes us back to the issue. If he says he's going to give us an opportunity to make representation and he hasn't, isn't this the same argument that I thought we were moving from? He hasn't
just
given
not
them,
relevant.
No.
and you say it's procedurally
Well, we
irrational.
submit that one hopes that when the NPA says the NDPP is going to make a decision and he will consult those affected by it as to when he will do so, that he keeps to his
And
word.
so, but you've said that he didn't. But
No, I
so
haven't
what's
said
the importance? What is the importance? We're not given an opportunity to make representation. What is the importance of the article?
Now, the importance is...
I think you can say it better than the article.
No,
Just to put it
I was
here.
coming to this point of the cumulative irregularities. And one of them is that the NPA spokesperson says, I will give those affected by it an opportunity, I'll consult with them, and they don't. I'll leave it at that.
But you have said so.
Excuse me?
You have said so that you were not given an opportunity.
No, this is afterwards, my lord.
Yes.
On the 14th of Feb, Abrams writes to us to say we're not giving you an opportunity to make representations. Then on the 14th of March, the NPA spokesperson says, I will consult with those before I announce the decision. We, out of the blue, 2 weeks later, not we, my client, out of the blue, 2 weeks later, we're informed, I've reinstituted. It's a bit and bob. The Lordship knows the point. My Lord, I need to then close off on this notion of Mr. Abrams' decision being unlawful and invalid, and we're entitled to Pres 1, 2, and 3. Sorry, 1 and 2 for that reason. Not 3. But 1 and 2 we're entitled to for the 3 reasons that we articulate. 1, he didn't have the power. 2, if he did have the power, then he exercised the power in non-compliance with the prosecution policy. And 3, it was irrational on its face. So I now turn to, and I'll spend, if I may, till the lunchtime just addressing the question of unreasonable delay under my second basket, which is the permanent stay of prosecution. Now, the permanent stay of prosecution in our heads of argument starts in paragraph 232. Where is volume 2 of the bundle? Now, in paragraph 232, we spend much time dealing with Sanderson and the cases that you've heard about yesterday. And what we submit is this. A permanent stay we accept is radical and far-reaching. So we accept that. It's a radical remedy that we're asking for in Prayer 3, and we submit on the facts and circumstances of this case, it is appropriate, just, and equitable relief. In deciding whether that is so or not, we ask that the court have regard to what the respondents say in their submissions in paragraph 22, because that reference we would submit is of some will be of some assistance to the court. They say, without a foundation of fact, the inferences become mere conjecture or speculation. There can be no inference unless there are objective facts from which to infer the other facts which is sought to establish. In some cases, the other facts can be inferred, but if there are not positive proof facts from which the inference can be made, the method of inference fails, etc. And they criticize both Zuma and Thales for adopting this, let's call it speculation approach. And we submit that their stance, no speculation, is one to be adopted by the court in respect of our permanent stay. I'll explain why in a second. But in paragraph 23 of Sanderson on page 215, the debate starts by Krikler J, where he says the central reason for my view, and this says a significant break from the past, goes to the nature of the criminal justice system itself. In principle, the system aims to punish only those persons whose guilt has been established, and we emphasize the following words, in a fair trial. And this court will have to decide, will the trial against Thales be fair, bearing in mind not speculation, but the proven facts? And the proven facts, leave aside the unreasonable delay, as Ms. Adhikari will explain after lunch, are that Thales cannot obtain a fair trial on the facts and circumstances of this case. And what Krechler says is the profound difficulty with which we are confronted with in this case, and this court is also confronted with that profound difficulty, is that an accused person, despite being presumptively innocent, is subject to various forms of prejudice, etc. We heard all that yesterday. And we know that the critical question is in paragraph 25, Krechler J tells the world, is how we determine whether a particular lapse of time is reasonable, and they go to the length of the delay, the reason the government assigns to justify the delay, the accused's assertions of his right to a speedy trial, and prejudice. And we would emphasize, and I'm going to flip through this very quickly, I do want to emphasize certain aspects. 28. The amount of elapsed time is obviously central to the inquiry. Within a reasonable time. He says at the end of paragraph 28, in my respectful view, time has a pervasive significance that bears on all the factors and then not should be considered at the threshold or subsequent in isolation. Time does not only condition the relevant considerations.
Mr. Katz, that's exactly what Mr. Sikakane yesterday argued to us. So you can assume we've heard it because Mr. Sikakane had dealt
But
in
then I want
detail
to turn
with
to
that
paragraph
aspect.
39 on page 219, which distinguishes, if it does. Because in paragraph 39, the central question that I submit in this case needs to be dealt with in respect of Thales is to be considered. And that is this. In paragraph 39, it says, ordinarily, Crichton J says, and in particular where the prejudice alleged is not trial-related. And that was a large part of Mr. Zuma's argument. His prejudice was not trial-related. Thales makes no such contention. Their prejudice is trial-related. There is a range of appropriate remedies less radical than the barring of prosecution. These would include a mandamus, etc. A bar is likely to be available, and this is, we want to emphasize the following words, and this is central to our case. A bar is likely to be available only in a narrow range of circumstances, and we accept that. For example, where it is established that the accused, and we ask that the court underline highlights, take a yellow highlighter, a purple highlighter, a pink highlighter, and say, probably.
Hello, can I object? Can I
Yes.
characterize his case? Not mine, because he's mischaracterized my case. I don't want him to argue my case. I'll be fine.
As a
And
please,
that, Mr. Sikakane.
as a please, I make no characterization of Mr. Zuma's case at all, because his case was trial-related prejudice in any event. But he has an extra leg to his case, which we don't have. So his case is stronger than our case on this aspect. But I don't speak for him. Our case is narrower than Mr. Zuma's case. And more, one could say more difficult, but his case encompasses a whole range of issues which our case doesn't encompass. And that is this. But I want to emphasize this word. And a bar is likely to be available only in a narrow range of circumstances. For example, and I emphasize where it is established that the accused has, and we want to emphasize this word, probably suffered irreparable trial prejudice as a result of the delay. And one looks at the facts, the common cause facts. What are the facts? Thales comes to court and says, and Mr. Adhikari will deal with this after lunch, we have no witnesses. And the response is that we, Colonel Deploy, for the respondents, have gone to Interpol to look for those witnesses that you mentioned, and Interpol can't find them.
My understanding is that you have witnesses, but they are not available.
They can't come to
unavailable.
support.
That is what I've read. And again, if I misunderstood you, just let me know and point me to.
It's in the first, it's in the founding.
I'm not sure, with respect, that I understand the difference between having witnesses and having and there being witnesses who are not available. If
They are, but you have difficulty in securing their attendance to court.
not difficulty, impossible.
Impossible. That's what you have there.
Impossible.
Let's assume it's impossible. Yeah.
Impossible. We say in our founding
You say
papers,
it's
Yes,
But-
that is something that any presiding judge in any trial will have to determine if a particular witness is very essential to your case, and you cannot call that witness, and you cannot use other aspects. For example, video link evidence from Spain, Paris, Mauritius. Section 158 comes to mind of the Criminal Procedure Act. Then, of course, you would be prejudiced in your case, but that becomes then a trial-related matter. Until that point, can one really make that argument?
absolutely. On page 682 and 683, Colonel Johan Deploy confirms what he set out in Downer's affidavit. And in Downer's affidavit, he explains, and they explain in some detail why it is. Your Ladyship puts to me, is trial prejudice at this point really so? Bearing in mind these other opportunities. And with reference to paragraph 6.3 on page 134 of the record, Mr. Downer includes Colonel Johan de Plooy's affidavit. But the important point is, and Ms. Adhikari will, and I don't want to argue what she's going to argue, but your Ladyship puts to me an important question. The trial judge. When I stand up and I represent an accused, and the trial presiding officer says to me, the prosecutors put charges to you, what do you plead? And I say, I don't know what to plead because I have no witness to tell me whether I have a defense or not. How do I plead? And if that isn't trial-related prejudice on the common cause facts, our submission is we don't know what is. I can't even take instructions as to whether I have a defense or I don't have a defense to any or all of the charges. My witnesses are not open. No, it's impossible to have witnesses to assist me. The respondent's attitude is in various forms, which is, for example, rely on the International Cooperation Act, rely on Mr. Peter Hodis, rely on this one, rely on Mr. Kessie Naidu. That's what they say. They accept that Christine Gourier wasn't involved in the raised gestae of this case. So she is not in a position.
They accept that.
They accept, Mr. Downer says that.
Where does he say that?
He says, Miss Christine Gourier, let me answer it directly.
I thought he was saying the opposite, that she was there. Well, even if he says so.
Let me, I do.
Yes.
Fine.
She was part of the April 2004 agreement.
No, I'll explain where Mr. Downer says it. I don't want to make this. She says it in terms, and he uses the words raised gestae.
He used the term raised gestae.
Yeah.
That I
He
will
did use
grant
the
you.
word raised
But the
gestae.
fact is, she has been part of Thales since 2004, if memory serves
I'll
me.
find it. I will find it.
When the first agreement was reached.
He was part of the
Yes, but that's got,
delegation.
sorry, with respect. When in 2004, and let me. I have limited time, so I'm going to make 2 points before. I'll refer to the record where it's mentioned. It's paragraph 27 on page 143. Where in the middle of the paragraph, Downer says, it will be represented at the trial in terms of section 332.2 of the CPA by a company representative, Gourier, who it is common cause is not implicated in the raised gestae in any way and will not consequently suffer any dignity. Not involved in the raised gestae
Yes.
in any way.
Yes, because there are 4 people that are involved there. But what does it say? She was not there as a company secretary for that matter. That is what we're talking about.
Because she was an in-house counsel.
She was in-house.
And she only came on board in respect of this matter after the events that the indictment talks about, on the common cause facts.
No, I don't.
I think it is in relation to section 322 and what is understood in the criminal context of the raised gestae.
No, sorry. The common cause facts are that Thales committed certain crimes from one date to another date.
Yes.
Ms. Gourier only came on board in respect of this matter after the latter date. That's all. Mm-hmm. And I want to end and then hand over to Ms. Adhikari after lunch with the court's leave. But the court mentioned something to me in unreasonable delay argument. This is where I'm going to end my address.
It's the corporate identity.
The court will know that the prosecution have criticized.
Mr. Katz, I think one thing that concerns us here is when you make these references to Mrs. Gourier, she's not charged here in her personal capacity. It is Thales that is charged. So we understood that the respondent's averment also relates to that aspect. So in that regard, I think one has to just make that distinction as to when the courts deal with a corporate accused
I accept.
and when we deal with someone in person.
I accept that. I accept that. I accept that.
Not meaning that the person represents
accept
himself, but when the person is individually before you.
Problem, Justice Steyn, is this.
Yes.
The common cause facts are that there are 4 individuals who can shed light on the charges against us. Thales. Those 4 witnesses are not available. They're impossible to track down. And one can speculate that Gurrier, Hodas, Naidu, etc. could assist in the defense. Speculation. Look at the facts, the pleaded facts, and don't speculate. What we submit are inferences which are not justified on the
I
fact.
hope you are not implying we are speculating by that submission.
I would never do that.
Yes, thank
But
you.
when you make a decision,
Because Mr. Katz, in the papers, the 4 gentlemen seem to be ones that were having discussions here and there. And one of the complaints that Thales has is that there is no institutional knowledge about the issue. And they make the point that some of these people are not there. But the question that we were saying, or the point that we're trying to make, was that Ms. Gurrier seems to have been the legal counsel from day one, perhaps, when these indictments and everything were
yes,
formulated. Yes.
yes, no, that's right. Justice Prejudice, you're quite correct. The question of speculation comes like this. The respondents speculate as to whether Gurrier can shed light on the issue. On the facts presented by the court, and we use the words of Sanderson, it's probably the case on these facts that there is irreparable trial prejudice. And one can't speculate whether Gurrier, and not the court, I'm not talking about the court, the respondent's speculation as to the decision.
That proposition applies to both sides.
Absolutely.
Yes.
Absolutely. Absolutely. The last question I want to deal with is this. On this question of unreasonable delay, there is criticism of Thales for its so-called trickery in the 2004 Tetard withdrawal process. And I want to answer it like this. There was an agreement reached. It would seem that the NPA accept that the agreement, which would have resulted and did result in the withdrawal of charges in 2004 against Thales, was complied with by the first Tetard affidavit. We would think that's not an issue. But the problem comes in when Tetard provided a second affidavit.
When he had a change of heart.
He had a change of heart. And the NPA say that trickery through the change of heart means that Thales, open quote, are responsible in some way for that delay. Now the problem is this, we submit, is that when October 2004 came around, the NPA knew about what they now say 14 years later was so-called trickery. Because they knew about Tetard's second affidavit, which they'd received, I think it was July 2004. So in July 2004, they knew, on their version, that the agreement had not been complied with. Despite that, they took a self-standing, independent decision in October 2004, for whatever reasons, in compliance with the agreement, not in compliance with the agreement, to withdraw the charges against Thales. October 2004. At that time, we know.
Your submission doesn't exclude the further investigations which were conducted afterwards.
And then
You know,
2006.
no, my submission is this. They say that there was trickery,
Yes.
the Tetard second affidavit. The only point that I'm making in response to that submission is that despite what is now regarded as so-called trickery, wasn't trickery at all, because in October 2004, they knew of Tetard's second affidavit. They knew about it. Why did they take 4 months and then withdraw the charges against Tetard? against Thales. That's the only point that I make. And I submit it's unfair to tarnish Thales with trickery. So if there was so-called trickery or non-compliance with an agreement, it happened to their knowledge before their self-standing decision, a 6A decision to withdraw in October 2004. And so based on what we would call the unreasonable delay, the length of time, the reasons for it, and perhaps in ending, I want to submit that when the court considers the reason for the delay, the court, in our submission, will have regard to this. The reason for the delay is because of the unlawful, irrational decision of Mshe. Yes, vis-a-vis Mr. Zuma. But in doing so, one will think, well, we submit, the court should adopt this approach. Well, was this delay negligent? Was it systemic? Was it borne out by anything which can be regarded as, let's call it, less than salubrious? The court will have regard to the notion of, was it a bona fide mistake of Mshe? It was irrational, but it was bona fide, like President Mandela in the pharmaceuticals case. And we say, for that proposition, the court will have regard to what NAFSA ADP said on page 45 in the Zuma AD case, as well as paragraph 84. And perhaps I should end by reading this and then hand over to Adhikari after lunch. In paragraph 84, it says, it appears to me to be inimical to the preservation of the integrity of the NPA that a prosecution is discontinued because of a non-discernible negative effect of the timing of the service. There is no rational connection between Mshe's decision to discontinue on the basis and the preservation of the integrity of the NPA. Those are sort of comments which one could think of fall within a bona fide mistake. But then he goes on and he says, if anything, the opposite is true. In these circumstances, discontinuing, in respect of which the merits are good and in respect of this heightened public interest because of the breadth and nature, can hardly redound to the NPA's credit or advance the cause of justice or promote the integrity. The court below was right to take into account against Mshe the contradictory accounts. It does not assist Mshe to explain that he had lied to Mr. Dana, so there's a lie to Dana in telling him that he alone had made the decision to delay, when in fact it was McCarthy who had made that decision. If anything, this is the important point, it affects the integrity of the NPA. It is an ANDPP lying to a senior prosecutor, the admitted deception, compellingly, etc. So what we submit is this is not one of those pharmaceutical type irrational bona fide mistake by President Mandela. This is lying, affecting the integrity and admitted deception. And that's the reason for the delay. And the court will take that into account as to why Thales should or should not have its prayer 3, the permanent stay, bearing in mind what Ms. Adhikari will try and demonstrate is that it probably will suffer irreparable trial prejudice. So lying, admitted deception, affecting the integrity are all features of why there is a delay of 9 years through which Thales has no fault at all. And in those circumstances, we submit that the permanent stay is appropriate. What I haven't dealt with, but we do not abandon, is Thales' strikeout application. And if I may, 1 o'clock, have 1 minute, just to close off. Thales stands by its strikeout application. It is submitted that it was entirely inappropriate on the Swissborough line of authority for the NPA to have pleaded the way it did in this sense. Thales brought a small case, 80 pages, some difficult issues against three respondents, none of whom were Mr. Zuma. Mr. Zuma's not in our case. Mr. Zuma brought a different case under a different case number in a different forum.
You can deal with it at 2 o'clock.
As it
It's
is.
fine.
Well, in fact, I've had nothing more to say.
Nothing more to say. Come back at 2 o'clock.